look up this way.
See if we can figure out something.
Hey, Karina, you got here fast. Just going to wait for everyone to portal over. I'm going to let Judge Simpson play while I close the other one. So everyone hang tight. It'll start in just a minute. Okay. Oh.
Okay, all right. For today's now back in session, Honorable Judge J. Cedric Simpson presiding.
You may be seated.
Oh, good.
Court calls the case of the People versus Nicole Nelson.
Mansour, hopefully on behalf of Mr. Nelson. No, Mr. Nelson, Your Honor. I spoke with him this week. He said he would be here, but he's not here.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. That warrant will issue immediately.
Thanks, Your Honor.
Court calls the case of the People versus Juan Osorno.
Your Honor, Alexis Pluma appearing on behalf of Mr. Osorno. Mr. Osorno, could you just state your full name?
Juan Osorno.
Your Honor, we would like to set the matter for a preliminary exam, and I would also like to address bond briefly. Can I go ahead?
You get a client, now you want to do everything, don't you?
Yeah.
Oh, I'm just. All right, let's do the exam part first. All discovery is complete.
Yes, Your Honor.
Yes, Your Honor.
Would people have their witnesses available the 30th?
Your Honor, can we go 1 week out?
Any objection on behalf of the defendant?
No, Your Honor.
Preliminary examination in person, August 6th, 2024, 9 a.m. before Judge Bob.
Karina, we're on the same channel. Sometimes you
Esteban.
Your Honor, we are seeking to have the no go-to order as well as Mr. Osorno's GPS tether that has a hot zone at his old apartment removed. I believe APA Barossa was able to confirm that the complaining witness has moved out of that apartment. And Mr. Osorno, in the meantime, has been effectively homeless and sleeping over the bike shop that he works at. So he would like to be able to return to that apartment that he was renting with the complaining witness.
It describes that the victim is no longer residing at the apartment listed on the exclusion, listed as the exclusion zone. I see if we have a new address for her so that we can update it. Because of the nature of this case, I would not be happy about removing the tether altogether, but I just need to grab that address to update it. I don't have any issue with him returning back to the residence of the victim.
The Carpenter Road address.
Yes.
Right, okay, and then counsel, you indicated something about a no contact to or
sorry, I said no go to, leave the no contact order in place.
Good. Nope, okay,
Yeah,
so it's just a no
allowing
go
him to go to the department.
All right. When he's on a tether,
Correct.
is that? So is it an exclusion zone tether or
That's
Yes.
my understanding.
GPS tracking?
Exclusion zone. And Your Honor, I don't believe he has any idea where the complaining witness has moved to.
Okay, that. I'm just trying to find the original. Uh,
The original address.
well, no, I have that. I'm trying to find the original GPS order. Make sure that we. Well, the tether that's on him. Well, on the order itself, there's no box checked. It doesn't say it's an exclusion zone, but it has the provision of the Carpenter Road. So I'm sure they took that as an exclusion zone tether. But you're saying that people have some objection to just removing the tether in its entirety?
Yes, Your Honor, I just messaged my victim advocate to get an updated address for the victim to have the exclusion zone updated. That would be my request, would be to keep the GPS tether with an exclusion zone for her updated address.
But we don't have an updated address.
That's what I just.
Yeah, no, but right now, at this moment, we don't.
Correct.
The only reason I'm questioning whether or not and maybe I'll make the decision once we have the address, whether or not the tether is even necessary is because we weren't attempting to try to track him. We were only excluding him from a particular area. But that area is now not in question, but okay, why don't we do this? Sure, you got other places to go. Let me pass it. Let's see if we can get some information on that, and then I'll make my decision, my full decision on
Understood.
what to
Your
do,
Honor.
either come off or add an additional address. Okay. All right, thank you. Court does call the case, People versus Douglas Redland.
Michigan after for the people.
Is that you, sir?
Yeah.
Okay, come on up.
And you.
No, I called Redland. Yeah. Oh, okay. I was hoping that wasn't you because I have a note that this defendant's being treated at U of M for a contagious disease. So I'm glad you're not him.
Was 50.
What happened? It just died on me. Okay, give me a second. I was just trying to do a thumbnail. Now I don't know what you guys heard last. I was just trying to do a thumbnail, and every way that I move Judge Simpson and Judge Fleischer, it looks like they're fighting. So I was like trying to figure out how I can have them both in, and it was not working. I didn't even know because I'm listening to the browser audio, not the stream audio, if that makes sense.
No, that was the perfect answer. She's got it. Court calls the case, People versus Lindsay Rosnowski.
People.
Yes, Your Honor. This is Matthew Mansour, Assistant Public Defender with, and on behalf of Miss Rosnowski, who appears today via Zoom. Lindsay, can you state your name for the record, please?
Lindsay Farmer Rosnowski.
Oh, okay, gotcha. Okay.
Your Honor, I have relayed an offer to the client, I believe yesterday, and she would just like some additional time to consider that offer.
Any objection from the people? During probable cause, August 1st, 2024, 9 a.m. Fine, continue.
Thank you, Your Honor. Thank you, Lindsay.
Thank you, Your Honor. Thank you.
Court calls the case, People versus Jovan Smith.
On behalf of people.
Senator Overwater, Assistant Public Defender on behalf of Mr. Smith.
Bill Oxley.
Thank you. Your Honor, I'd ask to adjourn the probable cause conference.
Except with the license.
I'm sorry?
Hi, Bill.
No, what? That's the style?
Stop.
Is it?
Yeah.
One of them denotes the tether. So it goes with that.
Okay. I'm gonna go home and do that to all my shoes now. All right, what are we doing?
Judge, there's still a significant amount of discovery that's outstanding. There should be videos, probably still images that I don't have, as well as medical and medical examiner reports. So I'll be asking to adjourn this to a convenient date in August. I did speak with Mr. Childers about it.
All right. Any objection for
No,
that?
no.
All right. You want the, I have the 13th or the 22nd, if you're looking to get some time out.
I would say the 22nd, please.
22nd. Probable cause conference will be adjourned August 22nd, 2024, 9 a.m. Bond.
Before you continue bond, Your Honor, may I ask?
You want me to like make him wear shoelaces that match?
No, Your Honor. I would actually.
I didn't know.
There are.
Wanted me to change it to.
No, there's. I would actually ask that you keep the order that he can only wear mismatched from now on. But that notwithstanding, he is currently on a scram tether. It's my understanding there's been no violations, and he agrees that that remains appropriate. However, he's also ordered to come to community corrections for testing, and the financial implications of that have been a struggle. He's in school. He lives with his parents. They're on a fixed income. They are present here and supportive of him. I don't believe he has any criminal history. There's no indication from anything I've seen so far that there's any history of drug use or that any drugs were involved in this. This appears to be solely an alcohol issue in this case. So I would argue that the scram tether is sufficient to protect the community, especially seeing as he has been compliant up to this point. So I would ask the court to remove the testing requirements at community corrections, leaving the scram tether, and of course the shoelaces.
Any response from the people?
What is the frequency of testing?
Right now, as I'm looking at the order, it's 2 times per month. So 2 times per month drug testing, and then he's on a scram tether.
You know, frankly, Ron, I think that that's not asking too much. This is a very case of driving causing death. We have similarly situated defendants who are not while alcohol was, I do agree with Mr. Overwater that there's no indication that anything at the time that this crash had occurred, with anything other than alcohol in the defendant's system. I think that twice a month is not asking too much to make sure that there aren't any other issues.
But there's nothing either in his history or as you see in the case that would indicate drug testings and that indicates any abuse or use of any type of controlled substance.
No, I mean, he doesn't have a prior criminal conviction. I'm looking at a driving record. I don't see anything. So,
And at this time, his family does not possess a vehicle. So anytime he has to go to testing, he has to take an Uber there and back, in addition to paying for the testing. And they are unlimited financial means.
All right. Well, here's what I'll do. I'll change it. I won't delete it in its entirety. Okay. But what I'll do is I'll make it once a month, random. Okay. Kind of split the baby on that just in case something happens on that. All right.
Very much appreciated, Your Honor. That will certainly help.
Gonna need a new order on that. Okay. All right. Thank you.
Thank you, Judge.
You know, sometimes things in life are supposed to be a certain way. Shoelaces. Yeah.
He had a full set of pants on.
No, he did. He dressed up. He did everything he should have done. Gonna haunt me tonight.
One does want a hint of color.
Court calls case of People versus Marshall Thomas.
Nicole Hughes on behalf of the people.
Thank you, Your Honor. Assistant Public Defender Costello, based on behalf of Marshall Thomas, who is present to my right. Mr. Thomas, can you go and state your full name for the record, please?
Good afternoon, Your Honor. Marshall Thomas. His shoelaces, man. Anyway, go ahead.
Yes, they do, Your Honor. Your Honor, today is the date and time set for.
Hold on a second. Is that, do I have different sides of people going out right now?
Sorry?
Can you,
our advocates, which I was going to speak with them. I'll just step out.
well, yeah, and I don't know if the other side got all the way out, and I just don't want any problems in that hall.
Mr. Smith?
Yes, the last Clay case.
He's, his family here in a conference room on the side. So.
Okay, yes, but I just didn't see where the other side, I didn't see where your clients went, but I also didn't see where they went. And they kind of all left in a group. So if you can keep your people in until you're sure that hallway's clear of the victim's family, I would appreciate it.
Understood, I'll do that.
Thank you. Okay, I'm sorry. Where were we on this?
No problem, Your Honor. Today is the date and time set for a PCC. At this time, there is no offer, so my client is wanting to waive his exam and seek an offer at the circuit court level.
All right. Is that correct, sir?
Yes, sir.
All right. You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
Thank you. People also waive the right.
Yes, Your Honor, sorry.
It's okay. Preliminary examination having been waived, defendant is bound over on the single count.
Your Honor, we would waive any formal readings and stand mute to the charges at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 28th at 1:30 before Judge Conlon.
August 28th, 2024, 1:30 before Judge Conlon.
Very good, Your Honor.
Thank you. Bond will continue this matter. Thank you, sir. Court calls the case People versus Thomas Fanicelli.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vanicelli. Mr. Vanicelli, will you please state your name for the record?
Thomas Fanicelli.
Okay, what are we doing?
Your Honor, there has been an offer extended that Mr. Vannicelli does wish to accept. However, we'd ask for a brief adjournment so that the plea forms could be submitted. I understand the court is in receipt of a bond violation report as well.
Absolutely.
And in relation to that, I did speak with Mr. Ganatra regarding this. Mr. Vannicelli does admit to the use and relapse. He is in CCOP right now through Dawn Farms. He did inform his therapist of that. He has a meeting this evening where they're going to discuss a more intensive option for him. He's attending AA, NA meetings daily. He's very forthcoming with his substance use and acknowledging that he needs to have better support in place, and that the outpatient.
Do I have any written information regarding any of that?
No, Your
What
Honor.
you just said?
No.
Anything from the people, Miss Mahalik?
No, Your Honor.
Miss Mahalik? Excuse me.
And Your Honor, I can provide documentation. I just don't have that from, as far as Dawn Farms. I can provide that to the court if needed. I know that it does say on the bond violation report that he is scheduled. I thought it said that he completed intake and started recovery group on the 16th.
Correct. But on the 16th, he restarted recovery group, but that was from June 4. Anything else?
No, Your Honor, I would ask that the court take into consideration, Mr. Vannicelli is here. He understands what he is facing. He was very forthcoming with his relapse, and he's doing everything and trying to get the supports in place for his treatment in order to not have this happen again. He does have family support here in the courtroom, and we have reached a resolution that is a misdemeanor resolution. However, we needed to have the plea form prepared. I would ask the court to allow Mr. Vannicelli an opportunity to meet this evening with his therapist and get a better plan in action.
Well, I need a plan in place somehow. What I'm gonna do is I'll adjourn it out 1 week to the 25th, but in the interim, defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
I'll reconsider that anytime you get the information to me.
Understood. Thank you.
Thank you. Court calls case People versus Taylor Walden.
Good afternoon, Your Honor. Alex Parks on behalf of Mr. Walden.
Good morning, sir.
Taylor Walden.
Thank you.
Hi, I'm requesting an adjournment in this matter. We're waiting on some media discovery from the prosecutor's office to review with our client.
All right, any objection? Do we have a timing on?
If we could go at least 2 weeks, please.
All right, I'll just do it. August 8th. 2000, yes, sir.
Thank you.
2024, 9 a.m. or as your invite indicates, bond will continue. Thank you,
Your
sir. Court calls case People versus Aaron Washington.
Ganatra for the people.
All right, this is Matthew Mansour, Assistant Public Defender with and on behalf of Mr. Washington, who appears to my right.
State your name. Aaron Washington. Thank you.
Thanks, Your Honor. I have not had contact with him this week. I'm going to get his number now and then hopefully have a conversation with him. So if we
He's right there.
Yeah, I just met him 5 seconds ago. So the number I'm calling was out of service. So
Okay.
yeah,
That you got numbers and everything now.
I'm going to get that from him right now.
Okay. Probable cause conference will be adjourned. I'll make it August 8th,
Okay.
2024. 9 a.m. or as your invite indicates, bond continues. All right. Keep in contact with. All right. Thank you.
Thanks, Your Honor.
What? I would be like you. My recorder missed it. Really? They told me that you were real good at this job. You just missed it. He doesn't remember. Damn it. Would just be our little signal. Court calls the case, People versus Gavin Wells.
Alex Parks on behalf of Mr. Wells.
See how it feels when somebody just shakes their head when you're looking at this. All right, your name?
Gavin Wells.
All right, what are we doing?
Your Honor, we're requesting an adjournment in this matter. We're waiting on some media discovery from the prosecutor's office.
Will the 8th work, you think, to get all that together?
Yes, please, Your Honor.
All right. August 8th, 2024, 9 a.m. or as your invite indicates, bond will continue. Thank you, sir. Case of People versus Tierra Wright.
Assistant Public Defender Costa. Right. Who's present by. Ms. Wright, could you say your full name for the record, please?
Yeah, right.
Today is the date and time set for PCC. At this time, there is an offer for my client to waive up and plead under HIDA, wanting to avail herself of that offer.
So she wishes to waive.
That's correct, Your Honor.
Ma'am, you're waiving your right to have a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Robisi.
Thank you, Your Honor. We would waive formal readings and stand mute to the charges at this time.
Defendant every way formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in this matter will be set for
August 27th at 1:30 before Judge Constantine.
August 27th, 2024, 1:30.
Thank you, Your Honor.
Thank you. Bond will continue.
You're all set, Ms. Wright.
Court calls the case People versus Travis Goebel.
Afternoon, Your Honor. David Chan, we have Travis Goebel, who's appearing to my right.
Okay, state your name.
Travis Coble.
All right. And he is here. This is an arraignment.
Yeah, so we'll waive formal reading of the charges. Defendant will stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. You're demanding a pretrial conference in this matter.
Correct, Your Honor. We would like an adjournment about 30 days. We just got discovery yesterday. And I think there's
So you
another.
waive the time requirements.
Yes, Your Honor.
Would you like the 22nd or the 13th?
The 22nd would be perfect. He does have another matter in 34th District Court before Judge Oakley. And it's just providing proof of completion of inpatient residential treatment to just resolve that case.
Okay.
But I wanted to let the court know we're not playing hide the ball or anything here. That still needs to be addressed.
All right. So set his probable cause conference for August 22nd, 2024 at 9 a.m. or as your invite indicates, as to bond in this case.
Your Honor, he's in transitional housing, just finished 90 days inpatient residential treatment at Dawn Farm, and he's now in transitional housing at Cedar Park. Davey LaFave is his house manager. He is gainfully employed. He got a job. His boss of his job is also in recovery. Everybody who works at his job is in recovery. They do property management. So he's surrounded by people in recovery. So if he really wants to pick up again, he's going to have to work at it.
Is he being currently tested or no?
Every week,
Every week?
Sunday to random drug and alcohol testing every week.
Who's doing the testing?
Dawn Farm is his
Dawn
house
Farm.
manager. Yeah.
All right.
And his house manager is a sponsee of mine.
All right. What I'll do is I'll set his bond $10,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or use of any weapons. I'll order no alcohol, recreational marijuana, or any illegal drugs. I'm gonna, well, I'm gonna do this. I'm gonna order testing, but I'm going to provide Dawn Farm testing results to community corrections.
That'll be fine, Your Honor.
Okay. So what typically will happen, we'll send an order over to community corrections. You'll probably have to go over there and do an intake and everything.
Yep.
But we'll try to make it specific on our order. Then you'll have to sign a release with Dawn Farms to have it released over. Got it?
Thank you, Your Honor.
Right. Thank you. We'll see you in about a month.
Thank you.
Right. So it wouldn't be. Okay. All right, got it. Recalls case of the people versus Juan Osorno.
Assistant Prosecuting Attorney Morgan Burrows on behalf of the people.
Your Honor, Alexis, on behalf of Mr. Osorno. Mr. Osorno, could you state your name one more time?
Juan Osorno.
All right. You work in Washington County?
Yeah.
Okay.
Lived here most of my life, Your Honor.
Pardon?
Lived here most of my life, Your Honor.
Okay. You have any reason to go to Taylor or Allen Park?
No.
All right. What I'm gonna do is I'm gonna leave, at least at this juncture, I'm gonna leave the tether in place. I'm gonna have a no-go to Allen Park or Taylor, Michigan. Okay. All right.
And Your Honor, just to clarify, will the tether be set up so that if he were to drive through either of those city limits?
Does he have a reason to go that way?
Not at the moment, Your Honor.
But, just thinking,
Well, he just needs to be, while this is pending, he just needs to be conscious of that.
understood,
Okay.
Your Honor.
All right. I think if you're headed, I think either one of those directions, you kind of know that you're going to be traveling through. All right.
Understood.
Okay. And we'll send over the order on that. I'll remove the no-go to provision so you can go back to the Carpenter Road. Okay.
Thank you, Your Honor.
See, wait a minute. We're gonna need a new corrections order on this. That it? Okay, I'll see you in recess.
All right.
That was all.
Sorry.
This is why I'm hardly ever live Why I hardly ever watch Judge Simpson live because I have to be able to skip the long pauses. Also, I'm gonna turn this one off for a sec. Our cats don't eat human food as well. Ham is white meat, though. Judge, sound, please.
That's called the case of cases of the people versus Douglas Wren.
Afternoon, Your Honor. David Sheehan, on behalf of Douglas Wren.
Your name, sir?
Douglas Wren.
Thank you.
Mr. Ganatra and I have had an opportunity to discuss these cases. There is potentially a third case out there, and we're not quite sure. And we just found about it yesterday. So if we could just have a month adjournment and to find out what exactly it is. It's a 2020.
But it wouldn't have been authorized yet.
We don't know. And Mr. Emmons, APA Emmons is handling that case. So Mr. Ganatra would probably know way more about it than I would.
It's a one request that I think predates him being in court for you on these two cases.
Oh, it's a request. So we're not going to have a case here.
No, and it's not new criminal activity that would constitute a bond violation.
Got it. Okay.
2023 matter.
All right. So why don't I then put this up August 22nd date?
That would be perfect. And then we can find out what it is and we can maybe have a global resolution of everything.
All right. August 22nd, 2004, 9 a.m. bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Let's call the case People versus Brandon Lancaster.
Afternoon, Your Honor. Dan Guerin on behalf of Mr. Lancaster, Brandon Constituent.
Brandon Lancaster.
Your Honor, he apologizes. He thought he had more time to get home after work to change. He didn't, so he wanted to say he was sorry.
Oh, because he didn't have all of his pants.
Right.
Okay.
Half of them, yes.
Okay, fair enough.
Your Honor, I spoke to Ms. Hughes. I'm asking for an adjourned PCC date. We're waiting on a video as well as a possible referral for sobriety court.
Okay. How much time do you think you'd need?
About 4 weeks if possible, Your Honor.
Jeez, oh, Pete. Okay. It shouldn't take time off, right? I had because of my vacation, I have the 13th and 22nd, so. 13th is a Tuesday.
Yeah, I was gonna say, I'm looking at it. Can we go to the 22nd, please, Your Honor?
Spoken like a defense attorney. August 22nd, 2024, 9 a.m. Bond will continue. And thank you for the apology.
Thank you, Your Honor.
Thank you. Court does call case of People versus Jordan McKinney.
And Edward Dukes on behalf of Jordan McKinney.
Name?
Jordan McKinney.
Thank you.
Your Honor, there's still some negotiation that's going on. I'm asking for an adjournment to facilitate that.
Probable cause without objection, August 8th, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
For cause case People versus Kyle Staunch.
Your Honor.
And good afternoon, Your Honor. James Kowski appearing on behalf of Kyle Stout, standing to my right. Sir, can you state your name for the record?
Kyle Arthur Stout.
The time and date set for a PCC in this matter I would ask to adjourn this. I've got a private investigator working on some aspects of this file. I did hear the 2 dates that you had.
Well, I have more dates than that, but
Would it be possible?
I'm not going to share them with you, but go ahead.
Well, I have a conflict for the 13th, and on the 22nd, I'm planning on being out of the country. I'm getting my vacation for the first time in 3 years.
Okay,
Would the court be willing to move me 1 more week to the 29th?
if there's no objection from the people. Probable cause conference, August 29th, 2024, 9 a.m. or as your invite indicates. Bond will continue.
Thank you, Your Honor. Always good to see you.
And you, sir. Case People versus Alexis Perry.
Good afternoon, Your Honor. Good afternoon, Your Honor. Samuel Bennett praying on behalf of Alexis Perry. We both appear via Zoom and waive our in-person appearance. Good to see you, Judge.
All right. Perry, could you state your name, please?
Alexis Perry.
Thank you. All right. What are we doing on this case?
Your Honor, I reached out to Ms. Hughes earlier today to let her know I'm going to be requesting discovery, or I have requested discovery, asking for if we could do the 22nd of August, that would work with my schedule, Your Honor. Or the 13th actually was better. The 13th, sorry. Now that I said it
You
out
want
loud.
You're looking at the 13th is a good date for you.
That's perfect, Your Honor. Thank you.
Probable cause conference, August 13th, 2024, 9 a.m. Bond continues.
Thank you, Your Honor. And for the record, she waives her.
Thank
21.
you.
Thank you.
Thank you, Judge. Good to see you. Thank you, Ms. Hughes. Take care.
Good seeing you.
You too.
Court calls the case People versus Jeremiah Bosson.
Mr. Sinatra for the people.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Mr. Fossen. Mr. Fossen, will you please unmute your mic and state your name for the record?
Jeremiah Faison.
All right, very good. All right. What are
Your
we
Honor,
doing?
Today is the date and time set for a probable cause conference. At this time, Your Honor, I'm asking for 1 more additional probable cause conference date. I am waiting to see if there's any video discovery, and we're going to try and reach a resolution as well.
Before you start yelling at me about dates, did the 8th work for you last time or no?
Judge, I was going to say, whatever date you give me, I'll be there. I'm there the first.
Yeah,
thing.
right. No, I don't want to hear it. All
Even
right.
if it's- No, you wouldn't be, because it sounds like you're going to go on vacation, which I'm jealous of.
Well, yeah. August 8th, 2024, 9 a.m. or as your invite indicates, bond in this matter will continue.
Thank you so much, Judge. Have a great day.
You do so. Court calls the cases of People versus Edward Traeger versus Ian Beck versus Timothy Marvin and versus Gabriel Vieira.
Doug Malkoff representing Edward Traeger.
Yeah, Traeger. Okay.
Good afternoon. If it pleases the court, John Minnick on behalf of Gabriel Vieira, and also standing in for Allison Krieger on behalf of Ian Beck.
Got
And, good afternoon, Your Honor. Jamil Puja appearing on behalf of Timothy Marvin.
Okay.
Judge, we've been coordinating with counsel and Mr. Childers trying to resolve this case, and it is ongoing. Accordingly, we're going to ask for an adjourned PCC. The dates that work for all counsel that when the court would be here, we believe the best date is August 13th, the Tuesday.
The 13th. That works.
That's correct.
That works for everybody, Judge.
Probable cause conference in these cases will be adjourned August 13th, 2024, 9 a.m.
Thank you, Judge. I have one additional request, and that is with respect to Mr. Traeger. He has a no leaving the state condition of his bond, and he has a niece coming from France to be with him July 21 through 27.
Is she French?
I don't know.
She's French and she's American as well.
No, I'm just asking if she's French because I don't know what to do.
Yes, she is.
Okay, well, all right, but
So we would, and they plan to go to Wisconsin during those dates. So would you be amenable
Why?
to?
no, I'm kidding. I'm kidding. I did, they're just, I'm just,
I said yes months ago.
She's involved in aviation.
got it. Willow Run puts on a better one, but go ahead.
July 21 through 27, travel to Wisconsin.
July 21 through 27,
Yep.
and that's inclusive, so you'll return on the 27th. That include all your dates?
We return on the 26th or 27th.
Those are the dates that you gave.
Yeah, 27th. That's the date.
Okay. Any objection?
No,
Defendant may travel to Wisconsin. July 21st through the 27th inclusive.
Thank you, Judge.
Thank you.
Judge, on behalf of Mr. Vieira, he's moving out of his apartment on the U of M campus on July 23, and he has a lease on a new apartment off campus, but doesn't have, you won't be able to move in until August the 8th. His mother, who's a US citizen, lives in Florida, and his plan is to spend that 2 weeks and 2 days at her home. Prosecutor's got no objection, and it's agreed to an order. Do you need an order? If I can approach with one?
Well, hold on, let me just make sure. That's on Mr. Who? Which client was that?
Vieira.
Vieira. Just to make sure I have the right file I'm writing in. All right. So as I'm understanding the long and short of that, he wants to go to Florida.
Correct.
Okay.
Traveling on the 23rd of July, returning on August 8th.
23rd.
One sec.
And that includes your travel day, so you'll be back in the state.
He'll be traveling those days, those precise days, leave the 23rd.
Right, but I do these orders so that it's inclusive, so he'll be back on the 9th, really.
Well, Florida?
I mean, yeah, I mean, I just want to make sure that he's back in the state on the date, so I'm just including the 8th as his travel date back. So on the 9th, we would expect to be back in the state.
That's fine.
All right. Any objection from the people? Defendant may travel to Florida July 23rd, 2024 through August 8th, 2024 inclusive. All right. Anybody else going anywhere? No? Okay.
No.
All right, real good. Bond will continue in all these matters. Thank you.
Thank you.
Thank you, Judge.
That one. This one that was nothing, that bond just continued. What's the date I gave them? 13.
Yes.
Now she wants to talk to me. Courthouse case versus Rennell Johnson.
Good afternoon, Your Honor. Michael Dobie for the people.
For the record, Erica Julian appearing on behalf of Ronell Johnson, who should be on Zoom.
Yep.
Ronell, can you state your name?
Ronell Johnson here.
Thank you.
Thank you, Your Honor. We're continuing with additional investigation on both sides in this, we're requesting an additional 4 weeks.
That's correct, Your Honor.
22nd, will that work?
Yes, Your Honor.
Probable cause conference adjourned August 22nd, 2024, 9 a.m. or as your invite indicates, bond will continue.
Thank you very much, Your Honor.
Thank you.
You're all set, Ronell.
Mr. Dobie, good seeing you, sir.
You as well, Your Honor. Thank you.
Courthouse case, People versus Holly Brown.
Nicole Hughes on behalf of the people.
Afternoon. For the record, Erica Julian appearing on behalf of Holly Brown. Holly, can you state your name for the? Holly Brown. We are here for PCC and bond violation. I understand the court has received and reviewed the material that were sent over yesterday.
I did.
Thank you, Your Honor. The only request that we would have when we're discussing those materials, she is staying in a shelter in Livingston County. There is a separate DB having nothing to do with any of this. And there are some cross allegations in that case. So she's just requesting that we not say the name of the shelter if someone is listening on Zoom to where she's staying.
Understood.
Thank you, Your Honor. I believe that the materials that we provided were pretty thorough in terms of where Ms. Brown has been coming from and what her circumstances are and pertaining to the bond violation. So I was wondering if the court had any questions.
Well, I do because, well, I'm not sure how you provided the materials, but I'm not sure how that relates to the specific allegations of the bond violation. Because what I have, certainly, maybe one might be able to look at the consumption of alcohol, but there was the tampering that occurred for a 12-hour period.
So I am going to let Ms. Brown address that herself with the court. You can explain to him where you're at in terms of the allegation. I had forwarded her the reports the same day. And just so that Your Honor knows, she did intend to turn herself into the jail this morning, but she was unable to get a ride this morning. And so she's here for in-person court this afternoon. So regarding the tamper on 6/23 and then the positive on 6/25, the court is looking for either an explanation or an admission as to these two.
Your Honor, I don't have any clue why those were coming up that way. I know that I was called in to community corrections to have my unit replaced for servicing. And when on my way there, Ms. Julian called me and said that she received a notification from courts that I had a tampering and violation that she would, wanted clarification about. And I had no idea what she was talking about. I told her that I was just called in to do a replacement on the unit itself. I have only been at La Casa AA meetings and with AA people because I don't currently have transportation and a license to get myself to and from these places. And I have not had access or been in the environments of drinking whatsoever. The only events outside of AA are AA events that I've been to, such as there was a sober rave in Royal Oak that I'd gone to, but that wasn't even in the dates in question. So I'll stop with that. But I was completely confused. So I had the unit replaced. And while at community corrections, they had told me that I had this tampering and violation 2 counts. And I was in for my reading the week before during this time. And they said that I was all set, good to go. We'll see you next week. And so I was really unsure why I was getting that unless it was due to needing servicing. But I've seen, Your Honor, this is way too important.
Well, hold on a second. Just so that we're clear before you go on with your story.
Okay.
On June 23rd at the 12:56 a.m. time.
Yes, sir.
That's when the tamper is detected.
Okay.
With the unit. On the 25th, there isn't a tamper. It's just drinking.
I don't know why it's coming up with that unless the servicing part of it needed it. Because at the shelter where I'm currently residing, there's a locked door policy from 11:30 p.m. until 7 in the morning. And I didn't have access any of those days to alcohol or have them in my possession at a no drinking facility. And I was at the facility at both of those times, documented on camera. I believe they have at the shelter as well as my sign in and out sheet and documentation from the shelter staff themselves saying that I was there and there was no evidence of me using. The doors lock at 11:30. I'm a smoker. I come in and I pretty much turn out the lights and go to bed by midnight every night. So honestly, I'm telling you, I do not know unless it has something to do with the servicing aspect of it. I don't have access to there, and it's a couple miles
Does she
away.
want a hearing on this? Because I'm gonna tell you, I'm not believing what she's telling me.
Okay.
Then we would request a hearing and we would ask Community Corrections to bring a log of their, not just the violation reports, but if she's been indicating, and she did to me that day, that they called her to Community Corrections to switch out her unit. If there was a problem, and this would have been the unit that was switched out. After this, this would have been the problem unit, is what I'm saying, is that if there was a problem with the unit. So perhaps we hearing where Community Corrections can bring their documentation of what they did and when, and the servicing of their units.
How much time would the people need?
Emailing Community Corrections right now, and time that works for the courts, I can bring one of them over. Anytime that works for the courts, I can bring one of them over for a bond violation hearing, whatever the court.
All right, I'll set it for August. I'll set the bond violation hearing as well as adjourn it. This time the PCC out to August 1st, 2024. Actually, it's going to be at 3 p.m. because I got to be a hearing plus the PCC at that time. That's the bond in this case. Now, what I'm worried about is I issued a bench warrant without bond.
I understand, Your Honor. I informed Ms. Brown of that the same day that the court issued the warrant. I did instruct her to turn herself into the jail. I do believe that part toward the end of her letter that was directed to the court expresses that she was emotionally really grappling with coming into custody based on all of her circumstances that were outlined. I have continued to encourage her to turn herself into the jail. She was going to do so this morning, but she does not drive.
Ms. Julian, and I'll just tell you, that's part of my problem. Part of my problem is I know how you operate, Ms. Julian. You told your client, tell them what the right thing to do is, and they don't do it. And then today, or yesterday when we received the information and we understood she was going to turn herself in that morning. And so we were then trying to make sure that she was going to be on the docket at the proper time so we'd see her. So she was just sitting there and she doesn't turn herself in. And my staff, we're going all around trying to figure out where she is. And then I get an excuse she doesn't have a ride here. I just don't think she's going to do what anybody asked her to do. She's just going to make her own call on all this stuff. And I appreciate the circumstance that she's in and have great sympathy regarding that, but I can't let you just go around violating what the court says you need to do.
I do have in the next week before the first medical alcohol treatment with psychiatry through Packard Health and counseling through medical alcohol treatment. Another drug testing per bond order. And I also have general therapy with my counselor, my therapist, all of those appointments, as well as some medical appointments that are all before the 1st of August. I have not left the state, and I was here this morning. Was not able to get here to turn myself in, but I was here for this hearing, and I can assure you I'll be here on the 1st. I really need to make these appointments.
You shouldn't have had to go through whatever. And like I said, it's not like you didn't get the information from your attorney. You didn't get that. I'm reading everything she's sending me. She's doing a yeoman's job trying to represent you and do that. You're just not following through.
I'm in Fowlerville, if you're, Howell, Fowlerville area. I do not have a license and I'm really sorry that I was not able to turn myself in. I apologize for that. Thank you.
Did you call your attorney and say you couldn't make it?
No, I wasn't sure yet, but I,
See, and that's what I'm talking about. I mean, Miss Julian makes a representation to us that this is what you're gonna do. This is everything. And then the person that's defending you and trying to make sure that the court understands everything about, you're not even communicating with them to say, this isn't going to happen. And then you're not following her instructions.
she said she'd meet me at 1:45 and I texted her at 1 o'clock and said I'd be here at 1:30 and that I would meet her at 1:45. I didn't ask her for a ride, though. You're right.
She did text me, it was after the morning, I want to say noon, that you were not able to turn yourself in this morning and that you would be here at 1:30. So I said that to meet me here since you were going to be meeting me here. So
How'd you get here this time?
I had a friend of mine picked me up.
I think that what you want to do is you don't do what you don't want to do. And so you don't put the effort forth. And then everybody is sort of just misled as to what you're going to do. Well, it doesn't work that way. Because it puts a whole lot of people out. Because like I said, we're going on Miss Julian's representation of what she instructed you to do and what you said you were going to do. And you didn't do it. And then everybody's looking around. We don't even know where you are or that you're going to show up at this time. You don't get to make those choices. So at this time, and Miss Julian, you can file a motion regarding her additional appointments and other things that she may have to do. But at this time, defendant's bond is revoked, defendant's remand.
Your Honor, thank you. In the meantime, for the record, we are trying to see if we can resolve this case at district court level. So
Okay.
those conversations will continue. Thank you.
Thank you. Case People versus Peyton Wellheim. Helm.
Michigan.
Good afternoon, Your Honor. Alexander Hermanowski with and on behalf of Peyton Wilhelm, who's approaching at this time. Peyton, please state your name for the record.
Peyton Wilhelm. Thank you.
This is a time and date set for PCC. Your Honor, I've had conversation with Mr. Ganatra. At this time, we're requesting an adjournment for about a month so that he has time to do some things that I believe we're going to reach a resolution.
That correct, Mr. Ganatra?
Council provided me with some information. I'm gonna look into it.
All right. August 22nd.
Yes, Your Honor.
2024, 9 a.m. or as your invite indicates. Bond will continue.
Thank you, Your Honor. Thanks, Nimish.
Okay. Okay, thank you. Court calls the case People versus Travis Goebel. While we await him, did you get to each other and?
We did not.
No.
Oh, Shand, I sent you out to find Miss Page.
Went down there. Half they said they left.
I went down. I knew what I should have done. I should have gone to Miss Pate and said, find Mr. Shand.
Yeah.
She would have done what I asked.
Yeah.
All right.
Obviously
So-
much better at going direction.
People of the State of Michigan versus Travis Goebel. This is case number 23FB2420.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Goebel in that matter.
All right.
And on behalf of Travis Goebel, Your Honor, we are substituting in as counsel with the approval of the court and of the public defender's office.
Okay. And just so the record's clear, you were here on another matter with Mr. Goebel way Mr. Goble came into custody is he went over to community corrections like I told him to and see what happens.
We had-
Good things happen when you follow what I say, Mr. Goble. All right.
We honestly thought this had already been resolved and that was, we were going to, and actually I talked to Andrew about this case as well. So this was just a miscommunication.
All right. So here's what I'll do. The other case got put out to
22nd of
22nd. So I'll adjourn the probable cause in this case to August 22nd, 2024, 9 a.m. or as your invite indicates. I'll cancel his warrant.
Thank you.
Now that I know where he is, reinstate original bond and conditions. Okay. So before you warrant it out on this case, I'm going to reinstate the conditions on that previous bond and the bond, which is a PR.
And we did provide Mr. Childress with confirmation of all the information that's stated in the court as far as transitional housing and everything. He's got all that information.
All right. Anything from the people on that?
I guess the only thing, this is just to the defendant's benefit. On the previous case, we set the bond that he's to basically provide community corrections with the testing results from Don Farms.
Correct.
That should be in, maybe that should be in these bond conditions as well. So
All right. Yes.
That's a really good idea.
So, and if what we can do is just provide the same order on this one as the last one, that'll work. All right, we'll do that. He can be released from custody, however conveniently they can do that and get him out. Miss Pate, thank you for stepping out and coming over.
Thank you, Your Honor.
Notice. And shame on you, Mr. Shan, for not finding her. All right. Thank you. Court's gonna stand in recess. Yes.
Okay. Just a sec. I have a feeling that I missed the first live of the day. No, I didn't. I can hop back here for now.
Two, 3938. This is Mr. Stantz. Case is very, very old. So, Tracy, can you make sure that his Scram device is operational within 1 week? And please let us know if, because it needs to get calibrated and in working condition. And then Victoria, we're resetting this case for 3 weeks. He must be back in 3 weeks in its plea or trial. So he either has to accept the agreement or we set it for trial. Mr. Stantz.
Yes, sir.
Hey, do you guys have an offer on these case? No. Do you mind putting an offer? Do you need the cause number? Do you have it or no? It's 232-3938. You probably the standard, you know. Okay, all right, Mr. Stantz.
Thank you very
Good
much,
luck to
sir.
you. Nathan.
Hi, Judge.
Hey, bud.
Apparently, Mr. Cooper tested positive.
Say it again.
I understand that my client tested positive, Your Honor.
Koopa?
Who's your client?
Koopa, C-U-P.
What did I tell you, Mr. Cooper? What did I tell you? Use your words. You know exactly what did I tell you? What's that?
That's supposed to do.
We were here exactly a month ago, and I told you, do not smoke weed, do not use anything, don't be in a car with anyone who hotboxes, because I will test you in 31 days. And if you test positive, what's going to happen? What did you test positive for? Goes with you.
If I can, Your Honor, the case is essentially restitution for dismissal, and him having to bond out is going to make the money go to the wrong person.
Sorry, bud. We'll talk, Nathan.
Yes. Would you tomorrow or in an hour?
Hey, you ready?
Yes, can approach Judge on Santibanez.
In custody or on bond?
She's on bond, Judge.
Page 23.
Okay.
Got a reset, Judge, and Victoria told us that she needs to be here next time because of the age of the case. My
Yeah, it's
client
getting
is-
old.
Right, Judge. My client is 36 weeks pregnant, and that would put her right at the time she would be either.
You have an offer in this case? So then bring her in closer to then. So I would suggest, I mean, if she's ready to get stuff done, we can bring her in closer to. You know, I don't want to wait till after, because then it's going to be 3 months. You know what I mean? It makes no sense.
Exactly.
So we can set it off a week, 2 weeks, 3 weeks.
Can I bring her in off docket, Judge, or
Sure.
is that all right?
Yeah,
Okay.
but I mean, we need to do some kind of reset date regardless, though. You tell me what you want.
I understand, Judge. Okay, I'll try to get her here before.
Have they only offered time served? Is that it?
It's an offer, but we're sort of in discussions. We might be able to, they're open to a possible PTI with some mitigation, and we're gonna get that together.
Yeah, but regardless, I have to put a date for a new one because today's, you want to do 2 weeks, 3 weeks?
I think I put you pretty close, so maybe.
You want to do 2?
We'll try to get her in sometime next week, Judge.
Okay, just pick a day. I don't care, whatever you want.
Gotcha.
Yeah.
It's all right. Thank you.
Thanks, guys. Hey. You right? Hey, Harold.
Yes, sir.
He didn't show up, so I'm gonna issue a warrant.
Okay.
And then-
trying to see if he can come back, but.
No, he knows, dude. You know what I mean?
I know.
Yeah.
I'm sorry.
I'll keep you, it is what it is. I'll keep you in the loop and then we'll just play the waiting game, okay?
Thanks so much.
For sure. Thanks, Harold.
Have a good weekend.
You
All
too.
right, bye-bye.
You ready? Um,
I don't know how it's gonna be like. Movies and trying to figure it out. Different kind of,
All right. Oh, please, you don't have to get up. All right.
What I understand.
Okay, guys, we're close. Let me see. No, close. So let's see. Okay, so we need to talk about the people who got into custody today. Okay, so on Blunt,
Doing it?
I'm issuing a warrant right now. He took a condom of urine to try to pass it off.
Oh, that happens so much, Judge.
So, yeah, he took a condom full of urine to try to pass it off as a drug test. So,
A
15,003.
Watch the work's gonna comment. But he's not here, right?
No,
Okay.
I ordered him to come back and he didn't come back.
Shaving all their hair. So that happens, and when that happens. That would be also.
Yeah.
The guy over. But it's like this. Yeah, it's like a very little town. Person backs up and drives around the top. So it comes. Like, listen, it's like, well, you don't have anywhere to prove that or anything damage on this. And actually, so they, the only way I actually say that is dash cam sugar.
At this point, the judge would be in chat, which, by the way, I didn't mod at all today. I probably should have, but I was busy with the stream.
Michael, are your ears burning?
I was here earlier and I forgot I had.
That's okay. What are we doing with Mr. Pete? Are you Mr. Pete? Okay. Okay, home slice. Who's next? No, man, we took a bunch of people.
Page 26, Tisdale. Petition for non-disclosure.
I'll take it home with me. I know, I'm so sorry. I have it right here. I'll take it home. Huh? Please. Oh, that's it. What about, what's your name, ma'am? You're with someone? What's your name, sir? Last name? O'Connor.
Page 17, it's in memory.
Mr. Connor, what time did you get here? Court is over. What time did you get here? Take a look. Did he check in? What time did he check in? Oh, okay. All right. We'll help you out now, Mr. Connor. What is your name? And hey, there's the other one.
Raymond.
You speak English? Yeah.
Yes.
Okay. Hey, both arraignments are here. So, okay. And your name and back. What's your name? Casas.
Casas was dismissed.
Casas, your case was dismissed.
I want to start with that. I'll print it off. I'll print it off. Come on.
Okay.
You want to start with O'Connor?
Yeah. Come up, Mr. O'Connor.
Page 17.
All right, Mr. O'Connor, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, on July 10th, 2024, officer on duty was waved down by a tow truck driver. The tow truck driver stated that another vehicle was involved in a crash and was attempting to flee. The officer was able to detain both parties involved in the alleged crash at the Shell gas station in Harris County, Texas. While speaking with one of the parties, he stated that the tow truck driver was attempting to repossess the vehicle that he was driving and that the tow truck driver slashed his tire so he couldn't drive away. The tow truck driver was identified by his Texas driver's license as the defendant. The defendant admitted to slashing the vehicle's front right tire and stated that the, quote, collectors told him to do so in order to repossess the vehicle. The owner of the Chevy Malibu stated that she would like to press charges for criminal mischief for
Hey, Judge, I did email you to do an interview. Also, we made you some, what do you call it? Like fan art? We were just talking about it. Merch. We made you merch art. Still catching up on your day in court. You must be so tired though, because people were really giving you a run for it. I sent it to the Fleischer one. And it came from, my cat is shouting. This is the cat that watches your streams. I sent it to Fleischer, I think. You must just let me know. Maybe I'll drop my email that I use for this. And then you're welcome to pop an email there, because I don't, if you put your details, then you might get a heck of a lot of spam. Donald, you met Alan, Mr. Allen. So, Judge, do you want to watch something different then? Is it weird to watch yourself? I've got Judge Boyd lined up as well. Spam? Oh, Evie, trust me, you will always get someone. I had someone today that sent me an email saying something like, oh, I came across your YouTube channel and I noticed that you could do with more subscribers. Email here. I gave that email out once. Someone find me the, oh, never mind, I've got it. Hey, Lisa, gifting memberships. It'd be funny if you get Judge Fleischer. Thank you, Lisa. Yeah, I'm online tonight. We were watching a trial yesterday, but it got very graphic. So I am not doing it live, and I am going to redact all of the A to the use stuff that popped up. Also, thanks for modding me. That was fun. I have a newfound appreciation for my mods because, oh my gosh, it is stressful when you have somebody else's channel in your hands.
For the damage she sustained to her tire, which was about $200.
This is a very interesting dilemma because that person no longer owns the car if it's being repoed, right? So if the repossession company is telling him, I don't know. I mean, this is a probable cause hearing, so that's something that we'll have to deliver. But
there'll be some more follow-up.
Interesting.
Yeah.
Mr. O'Connor, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand?
Yes, sir.
Do you have a valid Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
No, sir.
Then you're not allowed to drive. Do you understand?
I mean, I drive for a living.
Not if you don't have insurance, you don't.
Not a company truck.
Do you have liability insurance in your name?
No, sir, but the company have insurance.
I want to see where your name is on a policy before we allow you to drive. At this point, until I see it, I'm ordering you not to drive. I've seen how a lot of tow truck drivers drive, and it's truly scary how some of them drive. So before we let you drive, I want to know that you have insurance covering you for whichever car you drive. Until that point, I'm ordering you not to drive. You're welcome to come back tomorrow or at some point to show me that you have insurance. And at that point, I can take the restriction off. But until I know that you have insurance, it's all I'm asking you to do is follow the law. That's all I'm asking you to do. And I'm making it a condition that you follow the law. I truly hope that you take this seriously, Mr. O'Connor. If I find that you drive in violation of this, you're signing an affidavit with me today promising me that you're not going to drive until you have court approval and show us that you have insurance. If I find that you do drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive because it's an offense in and of itself. Do you understand?
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. So I will have you first come up here, swear to us that you're not going to drive. After that, I'll get you to Victoria. We'll have you sign a reset and we'll send you on your way. Good luck to you, sir. Oh, wait a second. Can you file no contact and no weapons, please?
I did.
Okay.
All right, Judge, page 17, Ortiz, come on up.
Teresa. Should we hop over to Boyd so that it doesn't put Judge Fleischer in a
So he
difficult
cannot leave yet because he
situation?
needs to sign bond conditions. Okay. You are Juan
Yes, Your Honor.
Fernando Ortiz.
Yes, Your Honor.
Mr. Ortiz, you're charged with harassing communication. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer be appointed to represent you, sir.
Judge, on June 10th, 2024, officers were dispatched to a harassment call. The complaining witness advised that the defendant is her ex-spouse and they share 2 children together. Complaining witness had advised that she had blocked defendant on her personal phone and she called him on their child's phone because it was his weekend with the children. Defendant and complaining witness got in an argument and he said he wasn't going to get the children anymore and he was going to shoot up complaining witness's new boyfriend's house. Complaining witness advised that the defendant called her numerous times from 4 different numbers. One of the numbers was 35 times, the other number was 10 times, the third number was 3 times, and the fourth number was 2 times. She knew it was him because he would text her phone multiple times from the numbers. Complaining witness advised that there had been previous family violence.
Okay. Mr. Ortiz, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
Yes, sir.
Order use a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. If I find that you have any communication whatsoever, because I will tell the DAs to get in contact with her to let her know that I've issued this court order against you. If she calls him and tells him that you're continuing to have communication, I will revoke your bond, put you in jail, make your bond so high you're going to flip. I don't know who you have in your life, but if you don't have anyone to pony up $5,000 to $10,000 to get you out of a bond, what happens? You'll be stuck like Chuck in jail until this case is over, right? Think about what you're doing when you're in the free world. All I want are my streets to be safe, and I'm going to do everything in my power to protect it. Do you understand? All right. I'm going to have you sign a reset with Victoria. I will then have you take your seat in the jury box. So we'll get your bond conditions. We'll have you sign it, and then you'll be free to go.
John, thank you.
Oh. Moa, what do you think? You want one?
Judge, honestly, on this case, the bond condition will suffice.
Okay.
So no more?
Yeah.
It's actually, also not, Mo is not enforceable on the harassment case. So,
Why do you say that?
the enumerated charges in which you can file a Mo on, harassment is not one of them. So.
I don't know about that one.
We've run this issue before where they violated the Mo and bond conditions. They're the same. They filed it under the Mo, that. True. And that's the way it was charged, at least. It could have been quashed, we already resolved it by then, but it's, yeah, on the verbal harassment. Bond conditions still are.
I guess let me know when it's in, and then I'll sign it because I don't see it in.
I don't see any other.
Did you file it on both cases?
I did.
Okay.
It might take a while.
And
Other than that, we're done.
So, yeah, go ahead, I'll wait for the proclamation.
and constantly, like every time someone comes up, the chat, Judge Fleischer's chat just goes stuck like Chuck, stuck like Chuck, stuck like Chuck. It almost looks like people copy and paste. Okay, well, since you've wrapped up for the day, we can watch. Let's see. I can watch Judge Boyd. Or that on for now. Audio. I actually I actually think I have a new one in Judge Kirkman. There was a long hearing, like family divorce hearing that was like 3 or 4 hours. I just want to check it out myself first in case there's any non-YouTube friendly kind of the content needs to be okay for me to just stream without worrying. And sometimes with long cases like that, if there's children involved, I can't take that chance.
All right, we're going to go back on the record in NIMAC number 760861, Vincent Alfonso Jr. If I can have parties re-announce, please, for the state.
Will Brooks for the defendant, Mr. Alfonso. Judge.
All right, and you're Mr. Alfonso.
I'm Alfonso Vincent.
Okay. All right, so where we left off is whether or not the defendant has been in custody past the 90-day mark and defense.
Judge, he is at 94 days in custody.
Okay. All right, so he's entitled to a bond that he is able to make. And so the current bond is at $15,000. And I know we started, but do you wish to call your client with regards to a bond amount that he's able to make?
If I may, for that purpose, Judge.
Yes. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Alfonso Vincent.
You may proceed.
Alfonso, the court has to make a determination as to whether to reduce your bond or potentially give you a personal autonomous bond today. So I'm appointed to represent you, correct? Correct. Do you have the ability to make the bond at $15,000? No, sir. Do you have bank accounts? No, sir. Do you have cash? No, sir. I've been locked up. How long have you been locked up? I got locked up April 3rd, so it's been over 100 days. Okay. And is there any family member, anybody that's able to make the bond at a current amount? No, I'm not from here. Is there any amount of bail that you or a family member could make? Not sure. I'm not sure. Okay. But as it stands right now, you're incarcerated. You have no money to make bail, right, and no way to make it. Right. Thank you.
All right, any questions with regards to bond amount? State? All right, I just have a few questions. So have you ever been diagnosed with any mental health issues?
No, ma'am.
Have you ever been on any type of medications?
For mental health?
Yes.
No, ma'am.
Have you ever been on any type of medications for medical reasons other than mental health?
I'm diabetic.
All right. And any drug use?
No, ma'am.
All right, thank you. All right, state, what are you requesting? All right, defense?
Judge, I'm just asking for the court to consider a personal recognizance bond. If not, then to consider the state's request.
So what I'll do is I'll set the bond at the bond amount requested by the state. This one. We don't have the order attached, but I'll write an order. All right, I'll set your bond at $1,500.
Offline, I'm guessing. Because if it's online, we'd love to we'd
Any
love to carry on
conditions being
watching.
requested by the state?
Judge, my only issue with that is, should he make bail, my expectation is that he's going to be picked up by law enforcement and transported to Dallas County. That's just my worry is that stops that from happening somehow.
Okay.
But I mean, maybe if the court would order within 7 days of release.
All right, I'll do GPS, waive fees, and GPS I'll order full GPS, waive fees. GPS to be installed. Within 3 days of release from custody. And counsel, if for some reason he's immediately transferred to the other county, just let the court know.
Understood, Judge.
And then that may change the court's order.
Okay, thank you, Judge.
All right, is there anything else? You're welcome. All right, Ms. Ferguson, on Mr. Alfonso, just give him a court date in 45 days.
Yes, ma'am.
Thank you.
Thank you, Judge.
You're welcome. And if you'll give him the reset form.
Yeah.
All right, thank you.
See that, that's.
Oh, he
the
was-
joke is that- Yeah. See, they all heard this joke, this topic is said every single morning.
Okay. I was like, pause, pause, pause. Wow, bug. Thank you. You got Greeners. You got Cindy Lou who is clearly a Dr. Zeus fan. Khada and Laurie and Sweet Tat. Okay, so I've hopped back here because there's a sovereign citizen in one of these that you don't see the judge that gets tased. And we need to find it because it's bothering my brain. Bug, honestly, someday I need to like gift you a year's worth. I don't know how.
Orientation also. Six. Oh, that works. Is she really? Yes. No way, she was. Practice with us. Yeah. My vacations are like.
I think YouTube has this.
I'm not, I don't, until my dying breath, I will not, until he ponies up the money he owes. Ever.
It looks like his last payment was in September, so he owes $410.
The minute he pays, I'll,
Then he can be off.
we'll
Okay.
take it off.
I'll
But
try to call him right now. If nobody's able to get him, I'll try
it's
to.
not, it's. I'm telling you, you're like, he has to want to do it. And when he's ready to do it, and he comes up here and he takes care of business, at that point, he will continue to. It's not fair, you know what I mean?
Oh, okay. Don't get you. Trust me, you're gonna afford it, you don't want to.
I'm like, what boss?
Hey, Judge. On page 33,
Yeah, I was gonna say that.
Dixon.
Big trial.
Have they 100% said that they will pick him up?
Yes, the sheriff's department just emailed me.
Ooh, it's a sexual assault of a child, yes. Yeah. It's aggravated.
Sorry, gotta skip anything child related.
What's on the,
What's the name?
no, the cause number?
242
Okay,
4725.
okay, let me, yeah, okay. And then number two, I have this. We have had a lot of problems with this person here. I've dealt with her quite a bit and
Email to the court.
yeah, it's literally been pulling teeth to get her here. It says now she's serving a 4-year sentence, but even before that, it was literally impossible to get her here. So what happened? Tell me about it.
She's here on the MAJ, is what I see.
No, but why is she got a 4-year sentence on
Yeah.
what was it?
Morgan Parish, that's Louisiana.
Hey, Mr. D.
Hey, Judge, may I approach quick?
Of course.
Judge, I got a young man by the name of Jeremiah Costling. Looked like he was a probation officer. Subsequent to the probation, he picked up an aggravated robbery.
Costling?
Costling, C-O-S-C-L-Y. Jeremiah Costling. He's in custody. The fee says an old case, but we might need to approach you on and see what you want to do. Picked up an aggravated robbery and 2 other co-defendants, I understand.
What happened on the ag rob? Did they hold someone up?
It's my understanding that 3 of them had AR rifles, assault weapons and rocks and rifles. On gunpoint.
I'm not sure on the case.
Can I give you a cause? You ready? Our cause number is 245-7840.
See what the allegations are. I think it was multiple defendants with AR rifles. But,
Can you please tell me what happened on the aggravated
Oh,
robbery?
yes, sir. Caught a suspicious vehicle prior to arrival. 4 black males wearing all black and hoodies wearing a silver Nissan. Officers arrived and they saw the Nissan speed through a parking lot. Observed no rear tail lights. Traffic stop was conducted. All officers were wearing dark colored hoodies, ski masks. While plain view, it was 86 degrees outside. The detained requested show up. Observed loose ammo in the driver's seat, floorboard, back seat. Search led to AR-15 pistol with no serial number under front passenger seat, and a brown and tan FNH 9mm handgun was also recovered. Glock was recovered. Defendant Costley was armed with a AR-15. Defendant Joel also.
So our guy had an AR-15.
Costly, yes, sir.
Yes, sir. Joel had a handgun that it couldn't describe, but it couldn't be described because the plain witness said the Glock was put into his mouth. Harris
In his mouth.
Defendant Harris put the black Glock handgun into his mouth. While Harris had the Glock inside the complainant's mouth, defendant Harris stated, "If you move, I will kill you." At which point complainant was in complete fear of his life. Costley and Joel both pointed their weapons at the complainant's stomach area and began to search his pocket, removing his iPhone and from his possession.
My goodness.
The witness also advised the suspects were the same as in an old call for service in reference to another cause number. And then,
Where was it? Was it at a house? Was it at a business? It's, hey, Mr. D. That's it.
Yes, sir.
So, I don't know, put at an apartment complex. Okay, so, I guess just do 120 with credit. And he's been in custody for.
I know, Judge, but I can't plead him out because it would be true that he picked up the.
No, he's got technicals.
He has technicals.
Oh, yeah. I mean, a ton. I don't think he did anything. I'm looking at the motion now. He failed to report.
Okay, I can proceed to that. Give me the, I get the chief to, give me a copy of that.
Yeah.
We'll see if I can work it on that.
Yeah, there's a lot.
Okay, great. That's what I mean.
And I wouldn't, regardless, I wouldn't do that anyways.
Yes, sir.
I'm not gonna, I would never do that anyways. Do you want me to bench warrant Ms. Harlan?
I was just,
Oh, it's a probation, right?
yeah, I was just gonna dismiss the MAJ in custody elsewhere.
Okay, let me
Cause
see.
I did confirm she's doing 4 years TDC. Or, Louisiana.
What happened then?
Attempted felon in possession of a weapon. I'm sure it's put down, but that's what she's there for. That's, so,
All to the best, except Adam because he's never here. Where's Mr. Subset? Let's see some tasing.
Don't drive. Okay. You see Senegal picked up a new case? Yeah. She's put on docket for Friday. Can you Zoom Friday? No, yeah, she's on docket with the new case on Friday, okay? And then I'm gonna put the BB on for the same day, okay? All right, thanks, bud. Bye.
Sorry, Judge.
For what?
Oh, no, you're doing thanks.
You're doing great.
Thank you. I take that as an endorsement.
Okay, who do we have here?
I have Mr. Simmons. Yes, Judge. DWI, first, 0.15. We've got an agreement. I think it's 7 for 7.
yes, sir.
Any prior DWIs?
Not that I'm aware of.
Have you checked?
DWI.
Check.
Yes, Your Honor, there are no prior.
Okay, all right.
When I had looked at the scene,
There's prior felonies, other things, the driver's well license suspended, but I don't see anything.
What federal case does he have?
There was a aggravated operation.
felony, not federal.
Oh,
Sorry. Is the another aggravated operation 18, another one.
another one. How many aggraves are you talking? Oh, my Lord.
Yeah.
It wasn't me. Leave it alone.
They were dismissed.
No es importante. They were dismissed. Done.
The last conviction I see here, Your Honor, was a assault on EMS in 2017. It was at Vernon.
You know, I would, guys, keep it down, please. I wonder, of all the cases you have, how much involved alcohol or dope? Right? I wonder how much of all the crap that you have in your prior criminal history, how much involved dope? If you get away from it, probably good things that happen to you, you know? You're now charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 7 days in jail, credit for the 7 days that you've already done. You give up a lot of rights by entering into this agreement. I'm gonna tell you now, you ever pick up another DWI for the next 5 years, you're gonna come here. You'll be facing a minimum of 90 days in jail. What we're doing today will not happen again. If you're not smart enough to think how to get home on a night of drinking or using, literally, all you gotta do is push one damn button. All you gotta do. If you're not smart enough to do it, you're gonna be doing at least 90 days in jail. Do you understand? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accused. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this, undo this. And I'm gonna tell you now, with your record, you get into a car, you get pulled over, you think an officer's gonna be nice to you? Right. I would never get in a car, even if you've had one beer, because I'm telling you, they're gonna hose you.
I'm gonna tell you right now, the cops are gonna be nice, because they are nice, but the conversation will end in cuffs.
Yeah, they will.
Okay.
They're not gonna be nice. Not with this
How
criminal.
you define nice?
You know, ag rob,
Just won't be home.
evading arrest, assault of a public servant. Do you think that they're gonna be nice to you? Hell no. Just don't get into a car. That's the best thing. All right, how do you plead to this offense, sir? I will find you guilty. I will send you to the agreement. I am going to suspend your license for 180 days. Do not drive until you get a license. Good luck to you, sir.
Thank you,
sir. Thanks, guys.
All right, go to the bailiff. I will say, Judge, over the weekend, I tried calling an Uber and I hadn't used the app in so long, I had to update it. And so you would load it and then it would it would go to the app store and then it would tell you to hit a button and then you hit, and it kept going back and forth between the same two screens and wouldn't. I
Maybe
think-
perhaps
I think
restart
I
your
updated
phone.
My phone. But
Yeah,
I will
but what, do
say,
you have a rotary phone?
basically, yes. It's a 3-year-old
Time to
iPhone.
update. All right. Let's And then so unstacked charming it. What's the word?
Tracy didn't send them to get drug tested.
So let's just tell them to hang out and we'll wait for Tracy to get back. There she is.
Louise. Judge, you ready to go over a few?
Yeah. Hold on, Victoria. The gentleman in the blue. Oh, last name, you remember? Sir, what's your last name?
Oh, he came back.
What was the last name again?
Douglas,
Douglas, that's right.
you sent him to get
Alright.
drug tested.
Yep. Come up, Mr. Douglas.
You're sending him for a drug test,
Oh.
American Collins, you want to come back?
Please. No, let's do tomorrow. Yeah. Take a seat for me in the jury box, sir.
Okay, Judge.
Yes.
On my client, this is what we decided to do.
Tell me.
Set it for a hearing. The chief is gonna set it for a hearing. How much time you need, chief?
Well, it's with
Yeah.
probation.
I need the probation file. Okay. I don't want a rubber stamp. He's charged with burglary down here and he's charged with aggravated robbery up there. I don't want him to have a conviction where I co-sign that he committed this. Because if he gets convicted of aggravated robbery, he's looking at a long time anyway. But if it shows that he's now convicted of a burglary too, that's going to make it worse for him. And I don't want to put myself in jeopardy.
That's okay.
Yeah.
Right. And I'm okay to have a hearing.
Yes, sir.
Let him know that if we go through the hearing,
I know
he's
it's
looking
not
at an
gonna be-
entire year.
I understand.
Yeah.
It's not gonna be no 3 days.
And I'm gonna tell you, with the facts that they put a gun into someone's mouth,
I understand, Judge. Oh, yeah. But he's not gonna do it for about one, so. One or two seconds, so you know.
So 2 weeks is 620.
Come up, sir. I see that you filed a motion for return of property, but you have a lawyer. The lawyer filled out the document, filed it, so I can't do anything until that lawyer's present. So you need to reach out to her and let her know that we can't do anything without her being present. He's not, the prosecutor's not allowed to talk to you while you have a lawyer assigned to your case and they're not present. So he can't talk to you when you have a lawyer. He's not allowed to. He could get in a lot of trouble by doing that. So what we're gonna do is we'll just let you go now. And then we can, I guess, set it off for a week and reach out to your lawyer and let her know in a week, we'll figure, you know, she can either Zoom on or she can appear in person and then we can talk about how to move forward. But I can't talk to you without your lawyer present. He certainly can't talk to you without a lawyer.
Even if my sentence is done?
Correct. The lawyer filed the document, you know, the lawyer's attached to that case. So we cannot talk to you without your lawyer present about the facts of the case, you know? So this is a motion to restore. So I guess let's set it off for a week.
We can get the cost number.
I have it. You ready? I've got it right now. It's 242-4725. And I don't know if that's something that you could put on for next week,
Because the case was dismissed,
but they filed a motion to restore.
right? It doesn't put it back on the docket. That just means counsel needs to come in.
Okay, so at some point, you got to get her to either come here or Zoom in, and we can figure out how to go forward. Okay? Okay, so you guys are just welcome to go. Yeah, okay.
Judge, hey Dixon, can you go with me? On costly, Victoria wanted to do 2 weeks, I was requesting 4, to actually like something to everyone I need. Is that okay?
I'm okay.
Okay.
I mean,
It would be the beginning of July somewhere.
so the bond is set at $30,000, right? And I mean, this dude's is about as dangerous as it comes, so I need to do some kind of conditions in the event that he gets out,
Sure.
you know?
Approach on, I mean, do you want to do conditions now? Or do you want him to approach?
Yeah, I guess we're gonna need him out then.
Okay.
Yeah.
So, beginning of July. Beginning of July.
So Mr. B always wants to leave. So that was July 8th. Okay. Okay, yeah, 7:15 sounds good.
Yeah.
Well, we're waiting on the
Yeah, I'd like to talk about Mr. Blunt as well. Blunt. I guess we'll talk about it in a second. Did
Sanchez?
you get the results of Blunt?
Yes, the same.
Where is it? Did you,
It's the same from last Friday. the same.
Mr. Blunt, come up?
Have a good.
Sorry,
Still waiting on results for
just take a seat for the jury box, sir, please. Just in the jury box, please. I'm waiting on this. You, Jeremiah Costley. Mr. Costley, you were placed on probation here for an attempted burglary of a motor vehicle. It's come to my attention that you've picked up an aggravated robbery. You know, I'm going to tell you that you really scare me, man. Truly, truly scare me. The allegations are that you and the complaining witness and the other co-defendants allegedly with ARs put a gun into someone's mouth. You know, I'm going to tell you just a side story that I have a friend of mine that I grew up with, not but a couple years ago, went through something very similar, and she was at her house, had someone break in because they are a family who, you know, does jewelry, right? Broke in and something very similar where tied him up, gunpoint, guns to the head. She's now so ravaged because of it. Can't sleep, can't hold a job. And the sibling recently tried to, you know, kill themselves. And it's such a scary thing that when you see something like that happen to a family, it really shakes you to the core. You never know in life how damaging you can be to someone. And it's just such a shame how it can just not only devastate one person, but can devastate an entire family and just cut them all short. And you know, the life that you and I live now here, it's so short, and it's so it truly is. And you got to be careful, man. You've got one life, and it really, really sucks to live 40 years in a box, in a 6x9 box, not ever getting to eat Burger King, McDonald's, going to swim in a pool in the summer, you know, never getting to play Xbox ever again. The life that you live now, it's either going to be a magnificent, glorious one where you can have fun times, go on exotic vacations, or it can be rotten, toilet, just miserable experience that just be careful, Mr. Costin, because you only get one shot, and sometimes the hole you dig is so deep, the lives you impact so just Mr. D is telling me that you want to set this for a hearing. You can do that, and you're more than welcome to. I extended an offer to you today. I'm going to tell you that if we set this for a hearing, you'll be looking at an entire year in jail if they prove to me that you have violated the conditions of your probation. Your bond now is set at $5,000. You also have a $30,000 bond upstairs in your aggravated robbery case. Pavel, what kind of conditions did they put in the aggravated robbery?
No contact with the complaining witness, Your Honor, and then no contact with the co-defendants, as well as no contact within 200 feet of the scene of the crime.
Tell me they put monitors on him, like leg monitors and.
Yes, Your Honor, there is a GPS monitor with the complainant's residence in place of limits exclusion zone, as well as curfews and electronic monitoring, obviously to show that he complies with the stipulated curfews and rules.
Okay, I'm going to go beyond that because you scare me so much, man. So if you do bond out, I'm ordering you to go under home confinement. You're not allowed to talk to anyone. I don't want you going anywhere. I don't want you having interaction with, the only one is with your lawyer. That's it. So, and that'll be prior to release. You're not, I don't want him getting out of jail without a monitor. And then home confinement, no weapons, no contact with anyone.
Yes, sir, Your Honor.
If, so you want 30 days for a hearing, Pavel?
Yes, Judge, and the soonest date would be July 15th. It would be on Monday.
Okay, do you, I'm not asking you to make a decision now, you know? Before we get everything up and ready, you know, I'll give you some time. I guess let's set it off a week for you to think about it. If you still want to go through the hearing, we will, but if they prove to me that you have violated the terms of your probation here, you're looking at a year. Do you understand, Mr. Costley? All right. Good luck.
Thank you, Judge.
Thanks.
I got one question.
Shoot.
I can ask a question?
Well, hold on a second. Let me get your lawyer here first. Ask Mr. D first. Why don't y'all,
You can't live with common sense. You can't use them.
hey,
No time.
with the allegation that we have on your aggravated robbery case, I mean, you can't go within 1,000 feet of any of the co-defendants. I don't care if they're, if Jesus is one of the co-defendants, you understand?
I'm just gonna mirror the felony and add the house arrest.
So there were 3 ARs in that case, right?
There was a named firearm, a Glock, and a AR pistol.
Can anyone get an AR?
Yes, Your Honor.
Of course. Anyone without a felon, yeah. Then if you're a felon, I guess you can buy them from the trees. but-
So if you're, tell me, if you have an open, an attempted burglar of a motor vehicle, you can still buy an AR-15?
Yes, sir, because it's a misdemeanor. No further findings or nothing, so, yeah, there's nothing to stop.
Good morning, Ms. Kizzy. Just go ahead, take a seat. We'll help you out here momentarily. Ms. Kizzy. Yeah. Oh, that I don't know if she went to go test. Yes, do you have the results on Douglas?
Yeah. PCP.
Come up, Mr. Douglas. You've now tested positive for PCP. I'm going to test you like crazy, and I'm going to tell you, if you ever test positive again after today, I will revoke your bond. I will put you in jail. Do you understand me? And I'm going to make your bond so high, you're going to flip. If you can't stop, you will be made to do it. You better try to excise these demons on your own. You don't do it, I'm going to do it for you. And I promise you, you're not going to like the way that I do it. You understand? You get now a ankle monitor to prove to me that you're not consuming alcohol. I'm ordering you not. Do you have a Texas driver license, sir? Do you mind checking, please?
Yes, Your Honor.
Do you have liability insurance in your name? That's a no. So if you don't have liability insurance in your name, you are not allowed to drive. And you will be signing an affidavit with me today promising me you're not going to drive. Do you understand, sir? What do you do for a living, Mr. Douglas? Why?
Looking for a job.
When's the last time you had a job? It's been that long since you've had a job. Why? What's the nature of your disability? What is it? Speak louder, man. How?
Toe don't bend.
Your left toe doesn't what?
Bend down, it doesn't bend.
So because your left toe doesn't bend, you can't work?
Yes, I can work.
Victoria, can you please reach out to the Mac for Mr. Douglas? Did you say there was a wreck in this case too, Mr. Douglas, in this DWI?
Yes, Your Honor, it was a vehicle accident.
A two vehicle accident.
Defendant's vehicle and like city vehicle. It appears to be a rear end drive.
I'm going to give you a lawyer today, Mr. Douglas, and I want you to look to see if you have liability insurance that says Calvin Douglas. If your name is not on any insurance card that is valid, then you are not allowed to drive. And I'm going to tell you now, if I find that you drive in violation of this affidavit that you're going to sign, I will have a contempt of court hearing. You'll be facing 6 months in jail and a $500 fine every single time you drive in violation of this affidavit. Do you understand me? I want nothing more than this public to be protected in the event that you get into a car and drive and have an accident so that the other parties can be taken care of. I don't care what your reason is. I don't care what you got to do. I don't care what baby you got to save. I don't care what kitten stuck in a tree. You get into a car and drive in violation of this affidavit, it will be HE double hockey sticks, if you get my drift. And I'm going to tell you now, due to the fact that you're testing positive for PCP, it stays in your system for 5 days. So I'm going to test you in a week. You will be back here in a week to test. If you test positive, it's not going to go well. You understand, sir? Okay. The next thing we need to talk about is what you're going to do for work. Because I don't want you bumming around doing nothing. Because when you have too much time on your hands, you become self-destructive. That's what's happening. You understand? So you must get a job. When we come back next week to take a drug test, I want to see what you've done to get a full-time job. If you've done nothing, it's not going to go well. So start putting in applications. Go to Amazon. They hire everybody. Understand, sir? I'm going to give you a lawyer today. If you have any issues, you can talk with the lawyer. Now know what's expected of you. No dope, no alcohol, no driving. Start the search for a job. I will have you go to, well, I'm going to have you come up here, swear to us that you're not going to drive. I'll have you go to Victoria, sign a reset. After that, you'll get with Tracy for your bond conditions. And I'm going to tell you now, Mr. Douglas, this isn't going to be an easy ride. You understand? All right, come on. Oh, I need the guardian in the lot paperwork because he just had a DWI. So you got it. Okay, good.
Judge, ready for the next one?
Oh, Harold, you're here. Wonderful. All right, come on up. As we were looking, PCP stays in your system, give or take a week. You tested positive again today. You know, Mr. Blunt, what I would like for you to do is, I was talking to your case about with a colleague of mine. And I think that the conditions that I put on you are a little arduous because it's too much for you to be able to get a job and try to maintain this type of condition. So I'm going to ease up on it, but I want you to get a job.
Yes, I have a job cutting yards. They've been calling me for work, but I can't leave because I have to get the monitor, and then they told me when I leave today, I gotta go get the other one.
Which one?
You asked me the GPS, I think, and the screen.
Okay. I don't understand how that can impact you from cutting the grass. How can that impact you?
6, and they call for work.
You want me to, so I can let you go a little bit earlier if you need.
Yes, I appreciate it if I can go out in the mornings to the evening because I work till.
Tell me what you want. I'm not gonna let you go in the middle of the night, okay? But reasonable, I'm happy to give it to you because I want you to work. So tell me what you want.
7.
Okay.
till about 6 in the evening.
6 in the evening. Okay. I mean, I'm happy to do that. Absolutely. So what do we have it now? Let me see. I can check. Mr. Blunt, I think that it's imperative that you work because you need to do something, and doing nothing is about the worst thing that you can do because when you have too much time, bad things happen. But if you're occupied with working, only good things can happen. I have here that your curfew is from 9 p.m. to 6 a.m. So that means that you can work you can be out and about doing work from 6 a.m. to 9 p.m. That's the curfew that we have on you now. I just don't want you out past 9 o'clock and out in the middle of the night. That's my only concern. But you can now work from 6 a.m. until 9 p.m. If you can do whatever you want to do, just don't drive. That's all we're asking you to do. Don't drink, don't use dope, don't drive, and no weapons. That's it. As long as you can abide by this, you and I will be fine. And don't test positive. I'm gonna test you in a week. I'm not gonna be as arduous with the testing, but I'm gonna test you in a week. I want to make sure there's no PCP in your system in a week. If there is, then you and I are gonna have issues. So I will ease up on the testing. So let's just come back in a week. Okay? I'll test you. Baby steps we will take. And if you can continue to do well with baby steps, that's how trust is built. Trust is not something that happens overnight. It's built little upon little. And if you do well, and if you continue to do well, okay? You have any questions? Okay.
You said that 1 week from today, Judge?
Yeah. Give or take. I mean, whatever's good for you, Harold,
No, that's fine. I should make sure. Let me see.
I don't want to make it so arduous that you can't work, because I think that's the most important thing that needs to happen now. And then hopefully with the work, you can make money little by little. You can get back into the kid's life. Don't bum rush, because that's good things will not happen at that point. Little by little, then hopefully they'll take you in little by little, and then you earn it that way as well. Yeah.
Just feel like we get Tuesday the 18th. It's Monday. I think it'd be before we can in the afternoon.
I'm okay with it, for sure. Yeah.
Which one did you open?
The one that's right
I'm
there.
gonna open the amendment on the first one. Additional order.
Tuesday.
Yeah, it says 9 PM to 6 AM. Oh. Yeah, that's wrong. Tracy, the additional orders are messed up. That's why. It says 9 PM to 6 PM. Right, it should say 9 PM to 6 AM. Perhaps that's,
Well, much of 9 PM is this one, the amended. I made it.
it's a new one that you created?
Yeah, you signed.
Anyways, we'll fix it, so it'll be right. Just, you know now. Okay? All right, just go ahead, take your seat. Or do you want me to sign a reset? Okay, come on.
Right this way?
It's okay. It's all right.
Fraser and the box.
Oh, my goodness. Oh, my goodness. Wow. I mean, I tell you, today's a day because not only did we get Mireles, but now we got Fraser to come in. I'm in true. Come up, Mr. Fraser. When we first met, you know, you were great. You know, what
We've seen
the hell
him.
happened, man? What happened? It's truly heartbreaking. What the hell happened, man?
Go ahead and sign for your reset, please.
Dope? Is that, I mean, what happened, man? How can I help? What can I do, Mr. Fraser? How can we straighten this out? Tell me. I want to help, you know, but I don't know if it's just too much dope that causes the control issues. Is it, I mean, when you and I first met, it was, it was, what the hell was it when we first met? I guess at 22 with the first DWI, is that what it was? Is that the first thing? Sure. I mean, since the DWI, assault, terroristic threat, VPO, assault, terroristic threat, evading, now an assault and a mischief. How do we make this, how do we get this to stop? What do we do? Tell me. I mean, I'm all ears with you. I want to do whatever we can. Is it, let's do this. Let's appoint him a lawyer first. And then I'm really happy that you're here. I'm really happy that you're here. Because at least that tells me you care somewhat, so we can try to work something out. Because when you first came here, you looked amazing. And I've like literally seen, and I don't know what I can do to help you so that we can stop this cycle. Something's got to give. I don't want you to kill yourself. Or even worse, someone else. Let's do this. Just hang tight with me. If you just go back to the box, I'm gonna get you a lawyer so we can figure it out, all right? Hey, I'm happy that you're here though. Just, you're doing good. At least you made it.
Judge, on page 3. Council failed to appear in May, so you just had me to do a 30-day reset. Today, he didn't show up, so I sent an email, and he said Gary came by and took care of it. Did you talk to him?
I didn't talk to him. Did you talk to Mr. Morgan?
On Kendrick Boyd?
Yeah.
Yes, Judge, we've actually, I found the dismissal to be as bonding question.
Okay, so it's being dismissed.
Yes, Judge.
Okay, all right. Mr. Boyd? Is he here?
I'm not sure, but he did approach in the very beginning, I remember.
No problem. Next one, Judge, is page 4, Cardona. This is supposed to be a drug test today.
We just checked in. So he's gotta go now. You want him to come back tomorrow? Okay, same thing with Miss Kizzy.
So Miss Kizzy, let's send her for a test and then she's good to go. We'll do, I think we said, hold on, Kizzy, let's see. Miss Kizzy, what did they do upstairs? What reset did you get?
I have a reset for 6 weeks. Let me see what they.
I don't know about 6 weeks. That's a bit
She
too
was
tough.
already tested last week. Today, we're supposed to have the results. But it's what
I want to do, let's just do one today and then let's do, after that, we'll do a couple weeks, assuming she's negative.
Hey, that was the first one and then, yeah, that was.
Let's-
May 28th.
Let's just do one right now and then let's give her, 2 to 3 weeks. We'll go from there. No, just go ahead. We'll have you sign a reset now. We'll give you a sheet of paper. And assuming all goes well, we'll keep with this date, okay? Come on up.
So she's getting tested today and coming back tomorrow.
No, a couple weeks, yeah. No, we still have the other guy that we need to talk. Oh, he's out there.
So, after this date.
All right, so I have signed to your reset.
July 17th, oh, no, sorry, July 9th. 7/9.
Hey, John, tell me what happened.
Judge, you talking to me, Your Honor?
Yeah,
I think John's trying to zoom on.
I know, I did. He's here now. I'm talking to him. He got Douglas.
So you told him 1 week to test?
Yeah, I mean,
6/17.
I'm chatting you, John.
I see that.
Just started pouring. Hey.
Okay. That sounds good. I apologize. We were on the road to
Do me
Montgomery
a
County.
favor. Do you mind hitting the button on the sound bar, please? There should be, right on the side, there should be a power button, if you don't mind hitting.
Ours are like crate.
Just, if you touch it once, it should come on.
The American
Say
ones we
something.
call crumpets.
Can you hear me, Judge?
No.
Not yet? No?
I saw a message that I
No,
wanted.
right on the side of the sound. You see it? All right, hit it one time. John?
Yes, Judge. Can you hear me?
No.
No?
Say something.
Can you hear?
There we go. Now we go. All right, hold on a second. Mr. Douglas, come up.
Someone said, I like that you're so interactive.
Do you have
and
a
I
cell
wanted to say
phone?
thank you.
What is your cell phone number?
713.
713 501 7794. Okay. On Zoom now is an attorney by the name of John Cedillo. The TVs aren't working for some reason, but he's been appointed to represent you. We're going to have you go out here now. You must get in contact with him. He's had your number. He's going to call you or text you. You must get in contact with him. You can talk to your case with him. If he comes back to me and tells me he can't get a hold of you because you're playing games and you're ducking and dodging, I will issue a warrant for your arrest. You will not get any more PR bonds. You violate these conditions, I will put you in jail and I'm going to make your bond sky high. Do you understand? I'm not asking for much. I'm asking you to follow the law and don't pick up a new case and don't test positive. That's all I'm asking. Understand? All right. Is he good to go?
Yes, 1 week.
Okay.
7.
All right, we'll give you a reset there. You're good to go out and then he'll reach out to you now.
Judge, what date do we have for him, if I can ask?
I gave him a week from today.
6, 7.
Yeah.
Okay.
Sure.
Sounds good. Thank you, Your Honor.
Thanks, John.
Thanks, Judge.
Take care, man. No, leave it on in case someone else comes, because we still have one more lawyer coming for Mr. Fleischer and it may be him or someone else. I don't know.
Then maybe this isn't the taser one.
Monday.
Okay, so he tests today. We'll set him off a week.
Don't see a tase there.
Yeah, or I guess to Thursday. Yeah.
Cardona, come on up. Next judge is page 4 and 5, Castillo. Monday, Thursday.
Right, okay.
Okay, actually.
5,001 on each.
Actually, since YouTube won't let me say my say, one, I'm making a certificate for True Crime Kitty and for Lilith, because those are the two that I've used thumbnails before. 2, Evie, I don't know what in the world you're referring to, because colonialism told us, give me 1 minute for it to load. I nearly killed the stream by accident. These are crumpets to us. And that's what the Brits told us. So now I'm even more confused. Pancakes to us are like this. This feels just like the whole biscuit thing, like, and then of course I probably have a freaking VPN on, so now it's showing me all American pancakes. No. Okay, so this is a bad picture. Does not look appetizing. But that expanded one, that's what we think. That's what we call pancakes. Scotch pancakes. What is Scotch pancake? Why are they Scotch? It is so confusing because, like, that's also pancakes in Poland. Like, English, like, anyway, should we make a quick swap to try find our subsit with Judge Fleischer? Otherwise, I'm going to have to watch these things by myself and literally go through until I find them. They said it was a day where you couldn't see the judge.
You can stop the video.
Okay, and then the other thing I wanted to say before I hit play, I'm really glad that we are not watching that witchcraft one live, because I've been like going to the laptop, seeing what's happening, and it looks like I'm gonna have so much to cut out. That's just like horrible. I love this conversation very much. Psychosaurus, is it the pancake conversation? Because apparently about 12 other people rage quit. Literally, like the views went boom. She doesn't know what freaking pancakes are. She said the word colonialism. I did, very confidently. So, there goes another 5. Sorry.
There. Here.
Fawn's not laughing. I don't hear any laughing coming from the lounge. He's lying.
Video said, yeah, because it just pushes the video from here to here. There's not a mute video here.
Now we've got tech support.
Quality, playback speed normal.
Is Eric here?
Yeah.
Do you mind getting him in? I'm just gonna start now, get them out of the way.
Okay,
Go there.
yeah.
Okay. Thanks. Okay, hey,
Good.
ready?
Ready.
You have an arraignment?
Yes.
All right, you mind bringing him up?
Mr. Stewart, he's in custody.
Oh, right. Let me go ahead with, good morning. Mr. Santana, you ready? Do you have an arraignment?
I did, the interpreter just left.
Okay. Good morning, counsel. Sorry?
I'm gonna sample.
Okay, you need a Spanish interpreter. Okay,
He said he'd be right back.
got it. Okay.
Very good this morning, Judge.
No, pretty good, no problem. So Stewart is last name, right?
Yes, sir.
What would a taser
Do
look
we
like
know,
if
do
you
they have any update on the robbery case that they were potentially gonna file? No? Are you flying solo today? Do we not have a chief?
Yes, sure. Simpson's gonna go here at some point.
Lavelle here today?
Lavelle's on vacation.
I looked into it a little bit as well, but all I could see was that one tiny little mention of it in one of the police reports. Other than that,
We're now here on number 4. Mr. Stewart, you now, from what I understand, have been charged with another evading arrest. You're facing up to a year in jail and a $4,000 fine on that one. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Okay.
Thank you, Your Honor. On May 31st, 2024, officers conducted a traffic stop in a marked patrol vehicle for fictitious paper plate. Defendant was the passenger. As the officer approached in full uniform, the defendant got out of the vehicle and refused commands to get back into the vehicle. Defendant then began running from the original location and into his grandmother's house. While he was running, officers in uniform repeatedly told the defendant to stop running. Upon searching the vehicle, officers found 113.8 grams of marijuana. The defendant ran for approximately 330 meters.
Where was the marijuana?
Where defendant Stewart was sitting, Your Honor.
Judge, the DIMS that I read said nothing about a fictitious paper plate.
Regardless, what we have is he's in a car, he's in the passenger seat, cops pull him over, he doesn't comply with commands, and then just starts taking off. And then when they search the car, they find a bunch of weed.
But it has to be a lawful detention. You're allowed to leave and run if they don't have reasonable suspicion of criminal activity, but which I don't think they had.
Well, I mean, they're starting their investigation, right? They haven't even begun to investigate. All they're doing is they're asking him to stay put, and boom, he takes off.
Which I think you are legally allowed to do unless there's reasonable suspicion at that point in time to detain someone, which there was not.
Did they?
Well, the DIMS do not mention that it's a fictitious license plate. It is in the offense report.
And I actually read that and I didn't see anything in the defense report either.
Is there like smell of marijuana? Is there what?
No, Your Honor, it is the officers conducted the traffic stop on the vehicle for a suspicious license plate that gave no return through the system. And then while the officer is approaching the vehicle, the defendant gets out of the car, refuses to get back into the car, and then runs away.
But a suspicious license plate is a conclusory statement. That's not a violation of the law.
Having a license plate that does not return anything in the NCIC, TCIC system is a violation of the law. You are required to register your vehicle.
What does it mean? What does he actually say in the police report? 'Cause I didn't see, maybe I misread it, but
We observed suspect touring driving a gray Chrysler variant paper plate F9523R, not returning to any vehicle.
Yeah, it's clearly a violation. They go up to the car. All they're trying to do is investigate, and boom, he goes.
so it said not returning to any vehicle.
Yeah, sure. When you run the that paper plate through the NCIC, TCIC system, it will return the number of the vehicle, registered, whether or not it has insurance.
Okay, yeah, I just didn't see that in the DIMS.
So, and you know, when you told me this, because when you approached me the other day, you told me that this was an old case from way back when. It's a new case. It's May 31st.
It was sorry for the miscommunication, but it was from before we had approached on the previous case. So we had been here, I think, on June 6th about the new case, and you had given him his bond conditions. This was from before that.
So what day did he get out of jail?
On the, what was it, ninth?
It was like. Cause I was in custody on 7.
He was released the 7th, Your Honor.
Of June.
Yes, sure. He was brought back into custody on the 12th.
What time of day or night was this? What is it? What time?
5 p.m.
5 p.m.
You have the bond, Judge. I just wanted to address the PC with you. I didn't see that in the police report, that it didn't come back. Maybe I misread it.
So tell me about the weed. What's going to happen with that? Because how much weed was there?
113.8 grams.
Do we know if that's going to be filed?
I'm not sure, Your Honor. I'll look into it.
All right, so Mr. Stewart, I'm going to find that there's probable cause to go forward with your case. Where do we go from here? I mean, we're now on charge number 4. How do we get it to stop?
Why you gonna, you could give me 12 to 11. I'm not trying to do nothing wrong. Like I honestly don't know.
Drama follows you, man. I know you're telling me you don't want to, but somehow drama follows you. Where do we go from here? What do we do?
I think he needs to get a job or get it, preferably get back to school, something.
Who?
To
So what about the other person? Logan, the other person get arrested as well? And who is that? So we can make sure that he's not hanging around. I'm gonna tell you now, Mr. Stewart, if I find that you're slinging, I'm gonna freaking lose it. Do you understand? If you're slinging, I'm going to lose it. You know that you should be on your best behavior. And there is over 100 grams, it's over 100 grams where you are sitting.
Your Honor, he did not pick up a charge in this transaction. However, he does have pending charges in the court's
The name?
Defendant's name is Christian Torin.
Okay, you're not allowed to hang around this person. Do you understand? And now, I mean, yeah, what do we do?
I think you're right that he needs to find something to do at this time. He needs to get a job. I wouldn't object to that as a condition of his bond or get back.
We have a curfew on him right now, Tracy, right?
No, I was doing new conditions. No, no GPS, no coaching.
Okay, so.
You do have an ankle monitor.
No, we do. I mean, I'm looking at it. There's 9 PM to 6 AM. And there is a GPS monitor. Right.
Oh, the additional orders, my bad, yeah.
Okay, so. I guess we'll just keep all conditions now. Okay. The conditions will stay as is. You pick up the 5th case. If I find that you do one thing wrong, I'm telling you, you will remain in orange. I'm not giving you a PR bond. So I don't know, you're gonna have to post it, get out, but I can't possibly give you a PR bond on your 4th case. So I don't know what to tell you, man, but if you do get out, you will have an ankle monitor. You'll have all the same conditions. No slinging. Do you understand, Mr. Stewart? You should know better than this. Okay. I guess that's it. We'll just put you back and we'll see. I mean, just give me a heads up if he bonds out and I mean, I'm not gonna give him a PR bond. I can't. You know, it's not on the 4th case, man.
Thank you, Judge. Thank you.
Sorry, man.
First Judge, page 11, Miranda.
Friends,
Me llamo Luis, de mucho gusto. Parece aquí en el centro. Y la nomás contesta sí, sí o no, señor.
And or 4th.
sorry, it's too late for translating. I also need to get things done, but I'm going to leave this on so we can see. Let's see if this guy needs to translate it.
I can be a push for an payment.
¿Necesitas intérprete?
Yes.
¿Hablas inglés? Listo. Please. Me llamo Luis, el intérprete, mucho gusto. Acérquese aquí, por favor. Solo mira el juez y le contesta con respeto, sí señor y no señor. ¿Cómo te llamas?
Armando Angel Hernandez Cordova.
Yes, sir. Hernández.
This is you.
Solo español. Yes, sir. You got it.
You were charged with driving while intoxicated. You were facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On June 6th, 2020. Construction workers had stopped the vehicle which was traveling the wrong way in construction zone on the west San Houston Turnpike. Officers observed the defendant's vehicle at the construction site.
hopping over to Judge Simpson. Then I'm going to go. I'm going to go do the bedtime things. Judge Simpson doesn't look like he was on for very long though. And we can continue our trying to find the sovereign citizen another day.
Well, the first is.
Okay. Be good. I'll still be watching chat.
The additions to the second session, Honorable Judge J. Cedric Simpson presiding.
May be seated. Judge, thank you for giving me the opportunity to talk to the family. There's 2 points that I thought of that well, the first is Ms. Blanchard was kind enough to forward.
Miss
the email.
Blanche, you mean?
But did I say Miss Blanche? I'm
Yeah,
sorry.
you made her like the ex-governor.
The ex-governor. Right.
I don't know. Go ahead.
Anyway, she was kind enough to forward me the email that she got from the medical examiner.
Okay.
And what it says, yes, it does say a skeletal trauma, and I'm sorry, it says a skeletal trauma analysis will be performed this month. Toxicology is pending. The circumstances are consistent with homicidal violence, but the body may not give a definitive cause. So it would seem to me, Your Honor, that if there was blunt force trauma, that would have been seen immediately to the skull. And I don't know what she means by the circumstances, but
Counsel, I think we need your client.
Oh, I'm sorry.
No, you just broke into argument. And I
Okay.
thinking he probably should be here for this. No, you can go get him, but they'll probably keep you. No, you can't get him.
And I appreciate the court's infinite patience.
Sometimes it's all I have. Are they bringing him?
Yes.
Is your matter? Go ahead, counsel.
Okay. Again, Ms. Blanche was kind enough to forward me the email she received from the medical examiner. And it says the body may not give a definitive cause. And it says toxicology is pending. I mean, this could have been an overdose. We just don't know. But what to me is important is that the skull she was able to examine, and there's no statement in here that it was the result of any kind of blunt force trauma. The second thing I wanted to make a point of, which I think is really, I thought about this after the court granted us a recess for me to talk to the family. I think on one level, having to borrow money from friends and family is more a guarantee of an appearance than if you paid a bail bondsman, because this is his family, and he'd be letting down his friends and family that are willing to post the bond because they have faith in him. I don't know that I really fully understood, or at least I thought I did, but did the court ask about a $500,000, 10% or $5 million?
Well, you were making the argument about getting money back and the like, and sort of balancing that against the something to guarantee his presence. And at least in my mind, that's what I was looking at. And so that's what I put that out there as you were arguing about the payment of the $200 or 200,000.
It's not. Anyway, if the court was inclined to raise the bond to something higher than 200,000 with a 10% provision, that would certainly be less onerous than a $200,000 cash bond. But again, the bond I suggested, which the court obviously doesn't agree with, I thought was reasonable, but even it's going to be difficult. They don't know whether they can post a $500,000 10% bond. They would certainly try. But I think they could post a $2 million 10% bond. So with that being said.
That they could post a 2 million if it were.
Yeah, it would take some. Pardon?
If it were 10%, it could be posted.
Yes, the family could, they think they could gather enough money from friends and family to post that kind of a bond. And like I said, I think it is more of an assurance if he's indebted to his friends and family than to a bail bondsman who he has no connection with. And I given, that they may never be able to tell the cause of death. And certainly I understand where the court's coming from, that this could be a homicide. And if it is, then obviously the bond may change, but it's not there yet. And, in this country, we are presumed to be innocent. So I think the $200,000
Counsel, believe me.
I know you do.
That is not.
You just are worried about.
It is not lost on the court. That whole concept is not lost on the court. Okay. But what also is not lost on the court is the other pieces that are there that aren't necessarily being argued. I understand it hasn't been charged. I also understand that people can't charge a case until they have enough there to charge. But there are.
But I've conceded,
the
Judge.
Fluid nature of the information that is causing the court some consternation, because this isn't, I have an event. We pretty much know everything about that event and we're done. What I have here is we have an event of some type. We're not even sure what that event necessarily was, but we see some of the manifestations of it. And then there are pieces filling in, like the phones,
right,
and those kinds of things that.
I get it. And Judge, I want you to understand this. When I made this bond suggestion, if it had been in a vacuum and there was no evidence that this could be a homicide, I would have not asked for $100,000 10% bond. I would have asked for a lower bond. So it wasn't like it was lost on me.
No, I know.
That's why I didn't ask for a personal bond, because I do understand how the court might want to consider that there's an open homicide investigation. But again, my point is not that it's irrelevant, because I don't think it's irrelevant, and I don't think I've ever suggested that it's irrelevant. But what I do think is that it's relevant, but so is the life that he has lived that anybody would be proud of up until this point. And so again, if it's a $2 million 10% bond, the family thinks they could raise that. If the court thinks that a higher bond of a 10% is necessary, obviously we have to defer to the court. But I do think the $2 million cash or surety bond is just not reasonable and is excessive in violation of both the Michigan and the United States Constitution. And thank you for your time, Judge.
Thank you. Ms. Bryant, anything else?
I feel like I just be belaboring all the points I made before, but I am, like I said, concerned with community safety based on the fact she was last seen with him. She's found dead and he's tracking up to Northfield. That's a huge concern. And even if it came back that she overdosed, he didn't even call. If that was, let's say that was the benefit of the doubt for best case scenario. He didn't call for medical. He did nothing. He dumped her body on the side of a road up in Northfield Township in our jurisdiction. So even if that was the case, nothing was done to help this person that was in his supervision at that time that he was with her. So even if that was the benefit of the doubt and that was the argument, that's what comes out, that's still, I mean, the fact that you're lying, making distressful representations to the police, lying to the police, and then this woman's found dead in our community. Honestly, Judge, a $2 million bond is not unreasonable under the circumstances.
I believe we are set for a PCC next week on the 25th. Okay, here's what I'm gonna do, and I'm doing this for a reason. Mainly to inure to the benefit of the defendant in this case. I'm going to, I've heard the argument here. You can supply me whatever other information you want to supply to the court. I'm going to make my decision. I'm going to move the PCC to 3 o'clock on the 25th, if that will work with council's schedule. I will also set my decision on your bond motion for that same time. I want to mull over some things. I want to look at it. I'm doing that, and usually I don't adjourn my decision on bonds to another date. I will usually make that decision, but I want to look very closely at some things. I also want defendant to at least, defense counsel, to at least get a preliminary look at the initial discovery that's there, so that, and have an understanding of what the court may be taking into account with what the people have presented. So that's what I'm going to do. I don't, like I said, I am not accustomed to doing that. And if I felt that absolutely the magistrate's decision on bond was an absolute abuse of discretion, I wouldn't hesitate to rule immediately. But I can't say that in my mind at this particular point in time with what I see. But I want to give you a chance to counter some of what the prosecution has put forth. I don't think that can be countered without seeing that discovered. Go ahead.
I appreciate, the court taking the time to really, give serious to consideration. I don't know that once I see the discovery, that I'm going to have any answers. I'm obviously not going to put forward a position factually at this early stage of the case.
Correct.
But what I would ask maybe is if the court would consider lowering the bond to something that you suggested earlier, and then if I can supplement it, I will do that. But I'd like to give him the opportunity, at least at this stage, to try to raise some kind of a bond. So if the court would be willing to entertain that possibility, looking at it in the light most favorable to the prosecutor, set some kind of other bond that is currently set, and then if I can convince the court that
I don't think you, counsel, I get what you're saying. I don't think you want me taking what I know now, looking at it with benefit to the prosecution. I really don't think you, I understand why you're saying that to me, but I don't think you want me to do that, because if I do that, I'm done. And I don't think I should be, because I want to make sure that everything that you have is given to me, and then let me make my ruling. People can like it, dislike it, but the one thing that you'll be able to say is that I looked at everything, gave everybody the opportunity to put forth everything before me, before I made my decision. And that's why I'm doing it this way.
Okay.
All right.
Thank you.
So the 25th at 3 o'clock.
If the
will
court
be the probable cause conference as well as that. Let me also ask this, Ms. Blanche, you may or may not know. There's additional evidence that obviously an investigation that's proceeding. Is there anything that's going to be anticipated is coming forth within the next week that would be relevant to this particular?
I can't speak to, I would have to, obviously, I know I've actively been reviewing search warrants, just like today I have, so there will be stuff coming in. I don't know within the next week what we will have.
Gotcha. Okay.
I think the most important thing, Your Honor, at this stage is the autopsy.
Well,
cause of death.
Correct, but in terms of my determination as to whether or not this individual poses a danger to the community or not, I think that there are other factors that may come in that may play into the court's decision that I don't know. Okay.
Thank you.
Thank you.
That time works for you?
Yes, it will.
Okay. 25th.
I am muted. Anyone have the timestamp at the start of this? Did we see this earlier? So I'm going to look up for that guy. And that person's in orange. I'm just going to skim. Because I'm pretty sure we watched everything for today. No.
So I'm glad you're not him.
Was a 50-50 shot.
No. We saw that lady.
I would actually ask you.
We saw Shoelaces guy. Hate it when I don't know the full story. My brain just needs to know. Also, I really need to get crack-a-lackin' on the evening. It's not these two, right? No. Oh, yeah. Is it this guy?
So I have more dates than that, but
Would it be
No.
possible?
Here was the guys that was like the group of nerds that did something. I feel like we would have paid attention to murder. Sorry, I know this isn't very riveting. But we need answers. See, there he went private. Okay. Then we skip forward. I think we missed this. I think we missed this. I think we hopped over.
you'll be taken into custody. You'll be taken into custody.
So is that 1 second difference? We saw the lady in plaid. I think that was the last one. Okay. No, not yet, because I have so much to edit up to put it all in the same place. The guy has appeared like 1,000,000 times. So when I go forward a second, then it started. But when we sit and wait, it hasn't. I don't know Psychosaurus, but I've written it down in my notebook, and we saw this lady come and press the thing.
Session, Honorable Judge J. Simpson presiding.
Okay, actually, do you know what? There's only one thing that I can say now, because we all watched this together and none of us remembered it.
Our membership figures stood at 700, listen properly, 769,820 and 70 members, down from 100.2 million in 2012.
Lilith, are you talking about the guy that was the other day that I said nobody watch? Close your eyes. I'd love to watch Judge Washington deal with him. She is so badass.
You may
Okay.
be seated.
I'm gonna crack on with doing the cat stuff.
And I'm just going to give an admonishment. I'm not making any accusations or anything. There are a number of people in the courtroom. Any outburst, anything will not be tolerated. You will be removed. If you keep giving me problems, you'll be taken into custody. and there'll be no questions asked. I hope everybody is understanding.
I think everybody understands.
Court does call the case of the people versus Fareed. Is it Hajar? Hajar? Hajar. All right.
Jessica Blanche, here on behalf of people.
Good afternoon, Your Honor. The court, please, Mark Krieg on behalf of Mr. Hajar.
And Ryan Marat, PA 3665 on behalf of Mr. Hajar, stand present to my right. Sir, please introduce yourself to this honorable court. My name is Fareed Hajar.
All right.
I would give my P number, but I don't want anyone knowing how old I am.
They didn't have them then, did they, sir? No. Everybody knew each other.
My partner, he started when there was no P number.
Got it. All right. This is your motion. He can have a seat.
Great, thank you, sir. I have filed a brief, but I have some supplemental information.
Yes, sir.
I provided the court with a letter from his employer. Did the court receive that? I think it's to Ms. Weigland.
When was that?
I'm happy to, if I may approach the bench. Your
Is
Honor.
that from a Jordan? That's it.
Correct.
Okay, I got it. Okay.
Your Honor, also, I have made a number of representations in the bond motion, and I corrected, there was one mistake that Ms. Blanche pointed out, and she's in agreement. I also want to point out one other thing. The two of us went through the guidelines, and on the current offenses, if he was convicted as charges to both of them, we agree that on the low end, it would be 0 to 17 months. On the high end, though, I said, I think 10 to 23, there would actually be 19 to 38.
Got it.
Okay. Your Honor, I understand, and I did listen to the bond hearing, that there is an active homicide investigation going on. I spoke to Mr. Surma at the Wayne County Prosecutor's Office, who is overseeing that investigation. And I've spoken to Ms. Blanche, and she agrees. Here were the representations. The cause of death has not been determined. The investigation is open. There is no timetable as to when that will be completed. And it's not even clear at this stage that there is a homicide associated with the body that was found. I indicated that he is a longstanding member of the community. He has lived in this country for over 40 years, over 40 years. He served in the military and the Marines, and I have a picture, Your Honor, that verifies his service in Marines at Desert Storm. To say that he has community support is a gross understatement. Present, I'll just give a number of people who would vouch for his credibility, for his desire to appear at all of the cases to defend himself on these charges. First is Oscar Garza. Would you stand up, Mr. Garza? Mr. Garza is a retired Detroit police officer. He was a sergeant in the K-9 unit. He has known Mr. Hajar for approximately 40 years, has known him since high school. He has never known him to be violent. Both his daughter and son are here, his daughter Eve and his son George. Would you please stand up? Eve is a biology student at Wayne State University. His son is a network administrator. Both of them, and this is a factor under the court rules, would be willing to act as a third-party custodian. I've spoken to them, and they are prepared to state under oath that if Mr. Hajar violated any conditions of his bond, they would immediately report it to both the court, community corrections, and also to the police. His ex-wife is here. They were married for 26 years. They are on excellent terms. He does not miss his alimony payments. She is studying to be an acupuncturist, and she lives in Commerce Township. Would you please stand up? His brother Kareem is here. He emigrated from Jordan in 1978, and approximately 6 years before the defendant, Your Honor, and he would also be willing to act as a third-party custodian and report any bond violations. Milo Quintanilla, who is his best friend, is a manager at the Trenton Engine Plant for Stellantis. He has known him for over 40 years. Mohammed Laham is a CEO of Laham Investments, and that is is involved in the automobile industry, towing, repairs, and a collision shop. His mother, Badia Hajar, is here, and she lives with the defendant. Could you please stand up? And also here is Mr. Mohammed Laham. He is a client. As I've indicated, he works at Kenwall Steel, but he also does IT work on the side. He has 17 different businesses, and he has said that Mr. Hajar is just an excellent employee and has no knowledge that he would ever engage in violent behavior. And finally, Your Honor, Sayed Khoury, who's known him for 25 years. He's a supervisor at Delta Airlines. All of these people in the community would vouch for Mr. Hajar. Again, Mr. Hajar is 57-year-old, a U.S. citizen. He's lived in the Detroit metropolitan area his entire time in the United States, other than when he was in the Marine Corps. He owns his own home in Dearborn, where he resides with his mother, sister, and son and daughter. And the daughter is a student at Wayne State University and majoring in biology. He has one prior misdemeanor from 2012. That's a DWI, which he received probation and successfully completed probation. He also has an associate's degree from Henry Ford Community College, and I've already supplied the court with a letter from his employer. He does have one prior drinking offense, but there's no indication that at this time he has any substance abuse problem at all. I don't know if the court had an opportunity. I did give the court the URL for the Zoom hearing on
I review all of them whenever I have a motion, so I'd seen it.
Okay, so all he said was he has, quote, the potential for violence. Outside of this offense, there's no history of violence. If he's charged with murder down the road, which certainly is an open question. So, when you're charged, you're presumed to be innocent. You would assume even more so when you're not charged. And that bond can be appropriate. Judge, I'm not asking here for a personal bond, although quite frankly, under the court rules, I don't think a personal bond would be out of order. I'm asking for a $100,000 10% bond with a GPS tether. He can only go to work, to medical appointments, and religious services. I think that is an absolutely reasonable bond. There's no history of flight. If the court has questions, I'd be happy to answer them.
In terms of the coordination, because it stretches over 2 counties, and you indicated that you talked to somebody from Wayne County.
Correct.
And maybe Ms. Blanche will answer this, so I was holding off in terms of the question. In terms of the murder investigation, as well as the potential charges, who would have those?
They would be our jurisdiction. So I
Got
don't know why Wayne County would say that it's their jurisdiction, because we actually sat down and had a briefing with Wayne County Prosecutor's Office, Dearborn Police, Northfield. They were present. The body is located in our jurisdiction. So if we can't prove exactly where, let's say it comes back as strangulation or something, it happened on the jurisdiction would be where the body is.
Body is,
So right now,
correct.
we have jurisdiction. If we do declare homicide, it is going to be in our jurisdiction right now. But obviously we are not there yet, but this is an ongoing active investigation.
Well, and that just so that you know, and I'm sorry to interrupt you there, but that's why when you said about Wayne County, I was curious, because it would seem to me that, at least from the sketchy facts that I know, that it would be here unless there was something else.
May I, Your Honor, and I
Yes.
can expand upon that a little bit. We've spoken, and I think she would agree with what I'm about to represent to the court. Wayne County is also involved in the case because they don't know where she died. And we don't know whether it's a homicide, but I spoke to Ms. Blanche and she agrees that it's an open investigation. No charge has been brought. There's no timetable, and they have not even at this point determined that homicide is the cause or the manner of death. So to hold this man on a $2 million cash or surety bond without even know whether it's a homicide and under what circumstances, I think is antithetical to everything that this country stands for, that someone's presumed innocent. He has not been charged. If he's charged, then whether it be in Wayne or Washtenaw County, then the court can set a bond that it believes appropriate for a murder, depending on whether the proof is evident or the presumption great. But the $2 million cash bond on offenses that theoretically the guidelines are 0 to 17 at best, and like I said, at worst 19 to 38 seems to me to be a violation of the 8th Amendment and the Michigan Constitution. If the court has questions, I'd be more than happy to answer, but I don't think I've made any representations today that Ms. Blanche would disagree with in terms of the homicide investigation.
Well, besides, I didn't want to get into the autopsy or what has been conducted so far because it isn't relevant to the charges yet, correct? But the fact that he's making these representations in court, the medical examiners are medical examiner in our jurisdiction, and she did say that the circumstances are consistent with homicidal violence. That is, last time I talked to her, she's still waiting for the toxicology. It's pending. We won't know cause and manner until after that is done, and she wants to, hold off on drafting the autopsy protocol. But that is all we have right now in terms of whether or not this is a homicide. Obviously, it's still being investigated, but I'd like to speak just now based on the charges when I can on why I would like the bond to continue as it is.
And if, Your Honor, homicide charges are brought, I will make sure he surrenders himself.
Yeah, but counsel, if I were to have that preliminary finding, and I realize it's not a finding, but that this is consistent with homicide. And then I have what was, at least from the documents filed by the parties, that there is some connection there. Why wouldn't I take that into account? I mean, what would be inappropriate, I guess, with the court taking that into account?
What I think would be inappropriate is that he hasn't been charged and he's presumed to be innocent. But let's assume that you can take it in. I think a $2 million cash or surety bond is still excessive. I mean, I'm not, like I said, I'm not asking for a personal bond. I'm not asking him.
Yeah, but counsel, what I'm getting at is you're indicating to me that there's no determination that it's a homicide.
I was not aware that there was a preliminary finding.
Right. I understand. I'm not saying that you're trying to misrepresent anything to the court. That by no means am I saying that. What I'm indicating, though, is that you want me to take into account sort of the absence of something where there's something going on and I now have something else, but you don't want me to take that into account. And I don't know that courts operate that way.
Okay. So let's take that into account. Then I think a $500,000 10% bond would be reasonable, but a $2 million cash or surety bond, it's no bond at all. And even on a homicide, bond may be denied. There's a recent Supreme Court case, bond may be denied where the proof is evident of the presumption great, but does not necessarily have to be denied. You can get a bond on a murder case where the proof is evident and the presumption great. It's permissive as to whether you remand somebody. But on the charges that he's facing now, he's entitled by the Constitution, both of Michigan and the United States, to a reasonable bond. And for a case.
So I'm hearing you, but I'm just saying the idea of what's going to be a reasonable bond is in a lot of ways also, you certainly laid out the factors in your brief, but it's also the circumstances and sort of context that I'm operating in as to what the reasonableness of that bond is.
Okay.
I mean, certainly that has to be taken into account. This becomes a different type of case in certain respects, because there is this ongoing piece of it.
I certainly understand where the court is coming from, but whatever, if the court does not feel my suggestion of $100,000 10% bond is reasonable, then the court can set some other bond, but 2 million cash or surety, no 10%, I just think is far excessive, given that what he's facing now carries under the guidelines, in worst case scenario, 19 to 38 months.
And I'll certainly let Ms. Blanche argue, but one of the things that I'm to understand is that there is, so a couple of things. One, that there may have been misrepresentations as to the knowledge of the individual to the police by the defendant.
That's been an accusation. I have not seen any discovery yet, so I can't speak to that. But I know that's been represented by, I've been told that there was a false exculpatory statement made. I'm aware of it.
Correct. And also the, I guess, the phone tracking data, which is also present. So, and my point to that is this, and I don't know how much of the discovery you've seen, what you've seen, or
none.
not. If you're telling me you haven't seen any, then I don't know what I necessarily do with that. But as I'm to gather from this, were this a circumstance of he knew the person or saw the person, saw with the person, nothing else sort of connects them there, and then the person a week later is found dead? I certainly get your point. I don't think that's what I have here, which places this, at least for me, in a different posture. Because and I'll certainly let Ms. Blanche give the argument and the information to the court on that. From what I gather here, I have, I think, his phone in the township, in Northfield Township. I have, so he's sort of tracked to where the body is.
That's my understanding.
And also, well, right, but then also that there is video where the defendant is in the presence of the decedent in this case. So it certainly, I'm not operating in the vacuum you'd like for me to operate in, because I think I've got something wholly different here. Now, there may be other explanations for it ultimately down the road. I'm not making that type of finding, but I can't leave that out and just ignore it either.
Okay. I get that, Your Honor. That's why I'm saying if the court doesn't feel $100,000 10% is a reasonable bond, then the court has a variety of bonds, $500,000 10% bond, $1 million 10% bond, but a $2 million cash or surety bond is no bond at all for all practical purposes.
Okay. All right. Thank you. Ms. Blanche.
Judge,
Your Honor.
Oh, I'm sorry. Was there?
However, the court's most comfortable. I just want to just add a piece.
Yeah, then I'll let them go first. It's your motion, so go ahead.
Your Honor, I would just argue that the factors that the court's relying on, what's been placed on the record, I still don't think is a nexus with a homicide charge. I think with count 1 and count 2, that's what the court's laying on the record here, is that if someone was allegedly found in a certain area, but there's been nothing placed on the record that tells us there's a certain dispute or certain violent tendency, certain behavior that my client is responsible for this. That has not been laid on the record. What's been laid on the record here is supporting evidence for count 1 and count 2 of this charge, not of any unrelated charge. There's been nothing before us that said that there was some sort of issue.
Counsel, let me just stop you there for a moment, because there's a bit of a problem.
Why is that?
Because yes, that's what you're dealing with at this point. But I think that goes to then ignore the fact that there is this continuing investigation into a homicide, and then with the information, just the brief information that was presented by the people, that what they're, at least the medical examiner is seeing is something consistent with a homicide. So, and I'll let you finish your argument, but I want to make sure that that you understand how I'm seeing some of this, and that is that if on the surface of it, something is consistent with a homicide, and then I have not just the defendant in the presence of that person, but then I have tracking data that would place him in the township near the body, I'm looking at something totally different. I get what you're saying in terms of the charges, but that becomes problematic, I think, from the court in terms of the setting of the bond and release conditions, because this is something that is fluid. So go ahead.
And ultimately, just to finish off, Judge, I don't see that anything's been placed on the record, despite everything that's been placed on the record, that a GPS tether, any sort of confinement provision with that 100,000, 10% would not be sufficient to protect any community. I mean, he's hired attorneys. He's going to be confined to his home. He's going to have to put up money. I mean, we have almost this entire community here behind us. We have his 87-year-old mother who lives with him, who he's caring for. He has his 2 children. I mean, his ex-wife, I've never seen an ex-wife come and support any of my clients, Your Honor, in court. So I think we have the community.
You just don't know the good ex-wives. Go ahead.
My ex-wife came to my,
I don't know.
my ex-wife came to my second wedding.
And just to finish this off, Judge,
Yes.
I'm not sure how many times the court hears this, but I've met with Mr. Hajar. I've met with his lovely family. I really, really think that this is an amazing person. I think he's going to adhere to any of your conditions. I understand that there's a serious situation going on, but as it relates to bond, I don't think that that anything's been placed that tells us he's going to violate a confinement provision or that he won't surrender his passport. He's willing to do all of this, Judge, and we have no problem with him doing this confined to his home and paying at least $10,000. But I'd ask the court to just keep that in consideration when ruling on bond. Thank you.
Ms. Blanche.
Judge, obviously the victim is deceased in this case. This was called in as a missing person. Her last phone location was at the defendant's house. They went to go question the defendant. He said he doesn't know who this person was. And then they started gathering his coordinates of his phone along with video. And based on the video, the victim's last seen going into his house, she never leaves. His car I think it's early in the morning, you see his car lights come on, off, and then you don't see the defendant leave his home until later the day when he tracks up to Northfield Township, and her body is located in the place that his phone coordinates and his car. There's video, different places up in Northfield Township where he's roaming around, and her body is then discovered a week later. So she's last seen going in his home, she never leaves, and then her body is recovered a week later up in Northfield Township. I think there's huge grave concern for the community safety. He's been dishonest with police. He acted like he didn't know her. Then he said, oh wait, yeah, I do know her. She was at my house, but she left earlier in the morning. So there is concern for community safety. And the fact that on the records in place, well, a GPS tether would be sufficient here. That GPS tether would tether him to the home that this allegedly took place at. The fact that we have a missing person that was last seen in his house. So we have a GPS tether at that house with also, he lives with his mom and his kids, who his mom, I believe, was present at that time. So you have witnesses, possible witnesses, that haven't come forward to the police or even been honest in this, and we want to tether him to that house. Judge, I'm sorry, but there's a huge issue and huge community safety based on misrepresentations by this defendant, and then also the circumstances surrounding this case. So no, I'm asking you to continue the bond, the $2 million bond. I believe it's reasonable under the circumstances. I was asking for a $10 million bond. If this was a homicide, I would ask you to deny bond. But we are asking for a bond. We're not asking you to deny bond. That's not appropriate under the court rules. The $2 million, yes, according to community safety, I believe it is.
Just briefly, Your Honor. If the court thinks he shouldn't reside at his own home, maybe we can make arrangements that he could live with one of his friends, his brother, or a close friend. So there was a Detroit police officer who's known him since high school. I'm not saying, Your Honor, again, I don't want the court to misunderstand my argument. I am not saying that you shouldn't at all take the homicide investigation into consideration. What I am saying is, even if you take it into consideration, he hasn't been charged with it, and a $2 million bond is no bond at all. I mean, if you wanted to go to a bail bondsman, you'd have a $200,000 premium that would be non-refundable. They don't have that kind of money. So again, maybe he can raise some money with friends and family. He's obviously got a lot of support, but it ought to be some kind of a reasonable 10% bond. That's all what I'm asking.
But Counselor, you would agree that the reasonableness, I mean, one of the things that you're arguing to the court is that he's not a danger to the community. Correct? I mean, go ahead.
I don't think that's not the standard. The standard is, are there reasonable conditions that can assure the safety?
Huge factor.
It is.
I mean, that's a huge factor.
It's an important factor. There's no question. But the question are there conditions that can be imposed that would mitigate that danger to the community? Nobody can say anybody is never a danger to the community unless, possession of.
Okay, so maybe you're not following what I'm saying. What I'm saying is this. If on the one hand, and I just hypothetically place an extreme out there of, I guess the extreme would be, in my mind, what the prosecutors laid out in terms of the woman goes into the house, she never comes out. He is seen leaving. We have his phone then in Northfield Township. We have her phone at his house, so we know that they're at some point together. That's one extreme. If on the other extreme, I just have, she was at his house, but at some point she left, her phone is someplace else or goes someplace else. And then something may have intervened that happened differently. You'd want me to take that into consideration in terms of setting bond, because that would cut against him being a danger.
I don't want the court to think that I don't think that danger to the community is not a relevant factor. I hear the court completely. I've been doing this for 44 years and I get where the court is coming from. My point isn't that danger to the community shouldn't be considered. My point is that the bond that is set is unreasonable. And you can consider in determining what the appropriate bond is. It doesn't need to be a $2 million cash or surety bond.
But counsel, maybe you
a $2 million 10%.
Maybe you agree or disagree with this, but the reasonableness, especially if I were just using the one factor of danger to the community, the reasonableness of that bond that I may set is certainly going to be dependent in some way with the risk that I see.
Correct.
Right?
I agree with that.
So it really requires me to sort of analyze what's there and what risk is there. I never forgetting he's presumed to be innocent. I'm not saying that, but just in terms of the risk of what evidence is there. I'm having a difficulty here at this particular moment. And because I don't want to, I want a full fair hearing for anybody that comes before me. But when you indicate to me that you haven't seen the discovery in some of the stuff that's coming out, and I'm not saying anybody's playing any games, I'm not saying any of that. I would just like the full-fledged argument. There may be a reason, if true, and I have no reason to doubt it, that her phone tracks to his house, which may be inconsistent with statements that he's given. There may be some reason for it. And I don't, where I'm at right now, and I understand why you brought the motion when you did, but where I'm at right now is that gets put out there. I don't have anything on the other side of that. And there may be, and it may be unfair for me to be looking from you if you haven't seen even the preliminary parts of the discovery.
The only thing I know is what I listened to at the arraignment and the bond hearing at the arraignment. But let's assume let's say this was a murder, which it's not at this stage, and the cause and manner of death have not definitively been determined. I think a $2 million, 10% bond would be reasonable. So what I'm saying is the court should not have to punish him and make him pay a premium of $200,000 that is not refundable. So make it a 10% bond, Your Honor.
I don't think this court gets in the business of punishing people with bonds. We just don't.
But again,
counsel, some people, sometimes the prosecutor thinks maybe the court's being too lenient or letting people go because of the bonds that we've set. Then there's defense attorneys that get all upset with us saying we're trying to punish people by the bonds that were set. I can tell you every judicial officer in this court, and I know certainly for me, I'm looking at a number of different factors. I rely upon counsel to give me all of those factors. I factor in all of the things that you pointed out. Factor in, is this person going to be a danger to the community? Is there a way that I can, given the circumstances of what's going on, safely release this person into the community and the like? Go through that whole analysis.
Can I throw something out to the court that I think?
Can I stop you? Probably not.
You
So
probably,
go ahead.
If you told me no, I would keep my mouth shut. I can tell you that. I've learned. Judge, the difference between a $2 million cash or surety bond and a $2 million 10% bond, the only difference is either way he has to put up $200,000. Either way he has to put up, but one is refundable and one is not. And even the $200,000 10% bond, the court keeps $20,000 of that for administrative costs. So all I'm saying is, Judge, if you're going to make him post $200,000, if he shows up, which is certainly isn't chump change, $200,000, that is a significant bond, and he forfeits it if he violates it in any way. And if the court feels that he should live with his brother, who would ask as a third-party custodian, so be it. But I'm asking, Your Honor, that all I'm saying is, even when you consider the homicide investigation, that a $2 million cash or surety bond is excessive. That's my argument, Your Honor. And whether—
Well, you just said two things to me, because I'm trying to figure out, and I want to make sure I'm getting your point. I understand you're saying that it's excessive. You're also making the argument, I think, that even if the net dollar amount's the same, that when all's said and done, somebody, whoever would put that up, would like to get some of it back.
Well, the bail bondsman doesn't get it back.
Oh, I know. I am aware of that.
But also, the difference is that he could possibly raise $200,000 with the understanding that he's going to show up. These people trust him. They would loan him the money. But with a bail bondsman, he'll never see it again, and nor will the friends and family that are willing to chip in to post a bond. He does not have $200,000. So I just don't think, Your Honor, what I'm requesting is unreasonable to make it a 10% bond. I mean, it's obvious this court is not going to, I've been doing this long enough, not going to follow my recommendation of $100,000 10%, although I don't think it's unreasonable, but at least make the bond as it stands a 10% bond, or make it $1 million 10% bond, or somewhere in between. That's my argument, Your Honor.
Just can I just put one thing on record, that discovery is available. They just need to request it from our office. It's been available since I had written the warrant. So I didn't want to make it seem like we were withholding discovery. They couldn't look at it prior to this argument. I don't think you're making that. But I'm just wanting that in the record so that like it is available, so they can just request it from our office.
He said he did request the investigator's report, but he hasn't gotten it.
I did email you for the investigators.
PA discovery?
I emailed your personal email.
No, you have to do.
No.
Okay, anyway, Your Honor, that's the argument. I just think that at a minimum, the court should make this a 10% fine. At a minimum. I mean, I've never, I've been doing this for 44 years, shown this kind of support at a bond hearing, ever. I mean, he's got strong ties with the community, served his country honorably, put his life on the line in Iraq.
Counsel, I'm not disputing any of that.
I know you.
That's what it is. I also realize I have people who may have led great lives, that when one's looking at it, they've led great lives, that all of a sudden something happens. Don't know what, maybe nothing happens, but all of a sudden something's in front of me that something has happened. And at that point, I have to sort of weigh and balance and try to determine what would be appropriate to have this person released.
Understood.
If I have someone who on one hand met somebody that night and then somehow or another through what nothing that really connects them ends up deceased someplace in the field or wherever, that's one thing. If I have someone who, and I'm not saying this is his case, lured somebody into a house and then all of a sudden kills them and then it takes them out and then dumps them into a field, those things on the surface can look the same, but it's a very different risk analysis in terms of what bond I set to then let somebody into the community.
I understand. Again, I'm not asking for some.
No, I know, counsel, and
But I think his 57 years should count for something, just as a homicide investigation should.
It does. His service to this country, it counts. The support, everything counts. It's a balancing for me. I appreciate the support that's come. I appreciate all the letters, everything that I've seen. All of those are things for this court to weigh. But there's something going on the other side of the scale too. Well, this is it. There's something on the other side of the scale, which the people have pointed out. And the problem, counsel, and this is where I want fairness, is that those things that the people are putting forth, I don't have a I'm not hearing a counter from you.
The counter is, Your Honor.
Well, hold it, counsel. I'm not saying, no, what I'm saying is this. I'm not looking for you to give me your whole case.
No,
I'm not looking for you to do all of that. All I'm saying is what the people have laid out, quite frankly, is some pretty damning things if those allegations are there. And I'm not hearing an answer. I'm not saying that I won't have an answer, but I'm not hearing an answer. And I think the reason I'm not hearing an answer or even some suggestion of an answer is because the discovery hasn't been seen.
My answer wasn't going to be on the merits of the facts of the case. My answer was going to be, the court said, yes, his life does count for something. And
absolutely.
So if that counts for something, and the homicide investigation also counts for something, which clearly this court believes, and I'm not going to challenge that at this stage. So they both count for something. So they both count for something. There's somewhere in between a $2 million cash or surety bond and a personal bond.
Well,
because
that's funny, counsel, because what I would really be arguing in between is what their original request was, which was a 10 million and a personal. So I'm not here to just pick a number. I really, that's not what it is for me.
I understand that.
It's not, setting bond is not a science, it's an art.
Right.
So it's tough to do.
Right. I'm not trying to beat a dead horse, Your Honor. All I'm asking is that the $2 million bond, he simply cannot make. So if the court made it 10%, there'd be if he can raise that, then he'd have to raise $200,000 which is certainly, as I said, not chump change. It's a significant bond. And I think given that he has not been charged with a homicide, but considering that that's something that is in your calculus, that's a fair and reasonable bond. That's my argument, Judge. And given his long life history that anyone would be proud of up until these charges, that is worth something. And what it's worth, in my estimation, is a reduction of the current bond.
Counsel, let me ask. Okay. I have her phone tracked to his house.
Correct.
I have his phone tracked to the location of her body. What would you have me do with that? I'm not saying any of that can necessarily be proved, but what would you have when you're talking about me doing the calculus? What do I do with that?
You consider that down the road, perhaps there could be homicide charges of some sort, whether it be murder or manslaughter, and that be taken into consideration and is a factor. But there are also other factors that I think can assure conditions or a combination of conditions, meaning tether, passport, third-party custodian, that will assure the safety of the community. So again, I didn't ask for a personal bond in this case. I didn't even ask for a $50,000 10% bond. I asked for what I thought was a significant bond, but obviously the court certainly does not agree with that. And so what I—
and counsel, I'm wondering, and I know you're advocating for your client, I'm wondering whether or not you would agree with that if you saw at least the preliminary discovery.
What, a $2 million bond?
Well,
I would—
with something other than what you placed in your motion. And I don't know, counsel, and I'm not trying to put you on the spot in that. I'm just saying,
if and when he's charged with a homicide, he could be remanded.
But counsel, let's say it's not even the homicide charge. But I have those factors all in the charges what I have now.
Correct.
That's a huge risk.
Anytime someone is released on bond, there is a risk, Judge.
Yes, but counsel, there are different cases.
That's
And
right.
if I have some woman who has disappeared, who ends up dead, who the phones are at the same places, and then within the course of that investigation, I have someone that you want me to let out to say, trust him that he will do this, and I look at his life, I also have that other part that he's been deceptive throughout the investigation. All of that's got to play in.
Judge, I don't know, maybe I'm not making myself clear, but what I keep saying the same thing. Yes, if you want to take that into consideration, I understand that. My argument, Your Honor, is that if there's going to be a $2 million bond, it ought to at least be a 10% bond. And that, I think, is a reasonable bond. I've seen homicide cases, murder cases that I've done in my 44 years, and I've done nothing but criminal defense my entire career, where I've seen in homicide cases bonds far less than a $2 million 10%, where there's significant evidence. So what I'm saying, Your Honor, is what's reasonable. And what I'm arguing is a bond that one can't make is not reasonable, particularly where he hasn't actually been faced with, it's not charged with a homicide. So again, I don't want to lose credibility with the court. So I get the message clear, it's come through clear that the bond I've requested is not in the cards. But I think to have this bond where it's at and just make it a 10% bond where the same $200,000 is posted is reasonable and fair, taking into the facts in his life.
So counsel, if I set it at $500,000, 10%,
I don't think that's $500,000, Judge.
Oh, I can do math. Yeah, I get
Yeah.
it.
That's, can I speak with the family for a minute, Your Honor?
See, this is the issue, because he's saying this is not a reasonable bond, but he also in the same breath says it would be reasonable if it wasn't a surety so they could get the money back. So we can bring them, we can provide the money to release him, but we want it right back, so that's why it's unreasonable. So he does have access to the funds clearly to be able to actually pay the bond. So, in this whole reasonable thing, there's no case law that counsel has applied to this court saying that this conduct that's been set by the magistrate was unreasonable from the start. So at this point, Judge, I don't think the magistrate was acting outside its authority unless there's some law that can be provided. But based on the circumstances, the argument, I don't know how you are unreasonable at this point. Now it's just whether or not how we're going to pay for the bond.
Judge, my law is the Eighth Amendment to the United States Constitution, that buy-in should not be excessive. Judge, again, I do think, and I know this, I've appeared before Your Honor, not a whole lot of times, but a few times. We had a case, I don't know if the court will recall, where it went on for a year before it went from district to circuit court.
Yes.
But I am confident. I mean, we have all of these people who are reputable people in the community. His employer, knowing that he's being investigated, said he can have his job. If the court wants to confine him to his home and not let him work, so be it. But to sit in the Washtenaw County Jail, given his background and history, where he has not even been charged yet with a homicide, I think just a $2 million cash or surety bond is excessive. I don't mean, I'm just repeating myself.
No, I know.
And
I will give you time to talk with the family. I'll take a recess.
Thank you.
Let you know.
All right.
Okay, so since none of you were listening, basically, I've got all of the tabs pulled up to catch us up to how we got here today. I haven't got his bond hearing saved yet. I haven't found it. I don't know the date. I'll try and find that before tomorrow. But I'm going to give you a TLDR. A Brazilian woman came to Michigan. She was last seen with this guy who was in the Marine Corps. He's retired. He originally said that he didn't know anything about her. Her phone last pinged at his house. There's videos allegedly of her coming into the house, not leaving. Very strange. So from what I'm understanding, the defense said it was a potential overdose. What I read was that she was found naked and there had been some cutting involved in things. And so I just saw, first of all, Chini saying, I was, thank you. And then Vaughn's joke about that's a funny sound. If you don't watch Friends, you won't get it. But basically, every time Phoebe introduces herself to Rachel's sister, then her sister's like, that's a funny sound. So how could she have overdosed if she was found in that situation on the side of the road? The whole community supporting this guy, and we started at the end and then went back. So basically now I'm going to have to put all of it together and then tell you everything I've read, and we can make sure that we're caught up by I think it was the 25th of July. Let me just add that. On the 26th of July, from 3 p.m., we have the landlord tenant. So it's going to be next week is going to be a very Judge Simpson-y week. Anyway, let me leave this open. Okay. Wait, I can save. Actually, I cannot send you. Wait, I can. Fareed, George, Hajar. But I will fill everybody in on everything. So don't worry to go look it all up. I will fill you in. But like this will be my most likely my hyper focus until we reach the trial date, because this has really like something is weird here. So yeah. Okay. Good night, friends. Thanks for hanging out. We had the judge in chat again twice. So that's pretty cool. He likes the videos. He's subscribed. He has his notifications on. So should you. Good night. Sleep tight. Thank you for a fun chat. And I'll see you tomorrow at 1 Central African time.